So now we all know that Cabinet has approved the IBC amendments as well as the Companies Act amendments, and soon it is also placed before Lok Sabha, and it will be approved probably this session. So that's the reason uh, now the institute wanted to have this particular topic so that we can get to know the subject before it becomes law of the country. So and so that we'll be well prepared to take care of the requirements of the new changes that is coming in insolvency bankruptcy code. Now moving on to the amendment part. I know many of you must be knowing it because these amendments right from August it is in discussion, and now as you all know now it is almost coming to the final stage, I can rather say. So we have to wait and see to get this parliament session to get over. So probably we'll have a complete idea once it the session gets over. By the time the bill may get approved also. Now moving on to our session part, I thought I can share my PPT and see before starting the session, I would like to share few things. Probably many of you may be a repeater of my session and few of may be participating now. So I would generally recapitulate the code, the purpose of the code before getting into amendment. Just see, going into an amendment uh, is important. More than that, it's more important to understand what exactly the law actually, okay? Then to move on to the amendment, what it's proposed, why proposed. So when we understand uh, the law as it exists today, then it will be easy for us to appreciate the changes which is coming across or which is proposed by the government and kept for the approval of the parliament. Okay. Now, why this code? We all know that. See, I'll take you through this amendment bill 2025 and the standing committee report also. I'll take you through and what are the changes. I don't think here this is the session just to abest our knowledge and just move on to that. No, I know as a liquidator, we are all challenging, facing a lot of challenges and lot of challenges before us in handling the assignments of under IBC, whether as a RP, IRP, or liquidator. So it is more important for us to understand how this law or how this amendment is really going to impact us. Okay, that is one thing, and impact the financial failures of the country, and how it is going to impact in implementation side, or rather we should say that practical side of it. Okay, how it is going to impact, that also we need to understand. So we need to have at least a 360-degree understanding before this amendment comes into law and it's getting implemented, because we are the uh, professionals, we are who is going to completely get into the implementation of this particular law, more than a government, rather I would say, because government they are only watching us, they are only regulating us. But as a professionals, many of you must be handling many matters under the IBC, whether it's a liquidation or CIRP. But today, the changes which is coming across before us, getting introduced before us, it is how it is going to impact, and really it is going to improve our level of practice, or it is going to improve, or rather I should say reduce the practical difficulties which we are facing as RP, IRP. See, basically the law, insolvency bankruptcy, as you all aware, they introduced in May 2016, and of course after introduction of NCLT, because NCLT later only they introduced, means to subsume the company law board and the powers of High Court, the National Company Law Board has been introduced to take care of the companies that matter in the initially, then later on insolvency bankruptcy code. So probably now what we need to understand, but why I'm talking all this, the standing committee has addressed all these issues. What are the issues in the code, and what are the issues in the implementation, and what are the issues in the NCLT facing, and little they discussed also what are the issue professors are facing. Okay. But not much into, because I don't think our difficulties have really gone into that level to there. But of course, they try to fill up the gap wherever there gap in the code in implementation side, not on specifically on addressing the issues faced by the profession, not specifically on that. Probably because their more intent, their motive and objective is to successful implementation of the code. Okay. So for that, they wanted to fine tune the provisions of the code here and there and wherever possible to make sure the code is implemented with a 100% result. Let's wait and see. Really, it is going to give 100% result, because we were all under impression, and in the year 2016 when the code has come, that we have got a complete code for financial failures. You all know that after Indian Penal Code and the Criminal Procedure Code and Civil Procedure Code, I should say that this is the fourth code in our country, which has got a complete. But of course, other codes are governing the functions of the courts in India, Civil Procedure Code and Criminal Procedure Code, and governing, addressing the penal offences in the country and the penal provisions thereon. But this is the code first time is introduced to address the financial failures and to more on financial sides of the or economy side of the country. Okay, so this particular code has got real importance. The reason being that other code, what I was referring, other codes are only introduced to govern the functioning of the courts, but insolvency bankruptcy code has been introduced not to regulate anything. It's to regulate, it is to make sure that the financial failures are addressed and the corporates are resolved, means the distressed corporates are resolved and resolution is coming forward. Because as you all know that earlier, before introduction of the code, there were companies which gone for winding up. Okay, years together, 10 years, 15 years, 20 years and all were pending. But government was thinking that, okay, by introduction of this code, probably all this can be avoided. The timeline could be reduced, and the company resolution can be given within a very short period of 180 days or 270 days. When the matters before, at the time of introduction of the code, the company is under winding up pending for years together. So this is the original intention. That's why the code has been introduced by after subsuming the provisions of Insolvency Bankruptcy Code and Provincial Insolvency Code. The Provincial Insolvency Code and Presidential Insolvency Act. All these acts have been subsumed by the code. And also few of the winding up provisions have been clubbed and few has been separated, and they completely ensured this is a complete code which completely takes care of the entire financial failures of the country and give a complete resolution, way out for the resolution for the bleeding companies, for the companies which are under stress of the or loan defaults and other issues. Okay. Now, after 2016, we should say another 7 years, 8 years, nearly 8 years. Probably, if you wish, you can share your thought before I'm moving on, because I will be moving on to directly to the amendments. So probably we can discuss with the amendments. But before kickstarting the that discussion on amendment, as a participants, probably as a practitioner, as a liquidator or RP, what do you feel about code? Really, it was moving towards the object. It has moved towards the object. It has really achieved the object to what it is, the purpose it got introduced. I know that the amendment is required to fill up some certain gaps, but as a professional, I thought I want to take your inputs before moving to the amendment. Then only we can productively can get into the deliberation of the present law and the amendment proposed and how it is going to make change. Any inputs from your side is welcome.
Sir, good morning. This is Velli Paramasivam.
Good morning, sir.
The code is good, but I personally feel now they said four pillars like IBBI and the government, NCLT, and IP are the four pillars. But especially the IPs have no powers. They are tortured. They are taken to task by any persons as they like. We feel very difficult to move with an IP. We have to definitely require the support of senior people or an advocate and make lot of filing with NCLT against the corporate debtors. That is the situation. I don't know when we are going to get relief from this. Anyhow, the act is good and code is good, but the importance or what is the responsibility and go along with that, the powers of IP is lacking, is my view, sir. Thank you, sir. Thank you.
Any other views?
Good morning. This is Visweswara from Hyderabad. Actually, I'm not handling any case so far, though I'm a registered IP. But my observation from the outside, see, Mr. Paramashivan has covered about the IPs and their problems and all that. But as regard to the IBC cases, bankers are nowadays preferring SURFACE rather than IBC. I think the IBC was totally utilized in the initial years of introduction, and I think it has come to, I think, not to that level. Many of the cases are PG to CD cases and all that, because after exhausting all their efforts through recovery from security through SURFACE, I think they are preferring to go against PGs uh, to get any something more than what they have recovered already through SURFACE. I think the amendments, I think if it takes care of some liberalization is required, I think admission is delayed in IBC, so it is a big hindrance. I think with the changes amended, with amendments that are going to come into force, I think there may be some developments definitely. Anyhow, we'll further listen from you so that we will be able to understand much better.
The liquidation period is reduced to 180 days.
Yeah, yeah.
We should all feel happy that government expect more from us.
Yeah. Sir, there are so many. One more thing is that there are so many, I mean, ambiguous opinions among us the IPs. The role of IP. Suppose if some assets of the personal guarantors are to be traced, is it the duty of the RP to go deep into, I mean, investigating whether the particular PG has any assets? Is it the duty of the PG or not? Or whatever that he has given, I think if it is verified, is it enough? I think some people are saying that it is not our duty. Some people are saying that we need to go deep into the affairs of the personal guarantor so that we will be able to give some results by way of recovery to the creditors.
Uh, but I should say there is nothing in law saying that there is no duty or there is the duty is left out or duty is the IPR liquidator is duty free, and the code wanted RP and liquidator to do everything under the sky. Okay, as long as they are permitted. Okay, the only question is that are they permitted only the law say, code says. If you are permitted, it is humanly possible or impracticable, all that is nobody want to understand. Okay, if it is permitted and the liquidator is duty obligated or RP is duty obligated, the lawmakers and government and regulator wanted to do. Whether it is practically how much difficult and all, they don't want to understand because
Yeah,
they it's your duty.
yeah, with the concurrence of CoC, I think the SCCA is will not be anymore. I think the CoC will continue as in place of SCC. It seems. So I think with the approval of everything from the CoC, I think we will be able to do by appointing some other agencies to investigate into the assets. The PGs will be our owning and all that we can do. I think.
After little understanding the amendment, when I go through the amendment for the deliberation as well as my own practice purpose, what I could understand in my personal view that IBC is becoming a big brother of surface. Okay? It's
Okay.
not completely. That was not the intention, I know, but still that gives that impression only. As a person, see, I'm a practicing professional, so I know better what's happening and what was happening and what's happening now, and with the introduction of these provisions, what is going to happen, all that we could able to guess with our practice, I'm saying. Okay.
Yeah.
Last 6-7 years we are into practice. Any other views?
Hello, am I audible?
Yeah, please.
So the code is actually getting more complex than not. In fact, of course, they've tried to simplify a few things in terms of 29A compliances. But where there are defaulters in implementation of a resolution plan, there is no such list which says that they are defaulters and that, an really get back to that list and ensure the same investors not come into their own processes. These are very simple things that the institute or the regulatory can do. But unfortunately, even these simple things are not really done by them. But yeah, the entire pressure is on the RP itself, who happens to be running the race also and also ensuring compliances. They do not understand that the RP is not supposed to be just in the courtroom. He is also to do some works even on the ground. Because otherwise, how are we going to administer the company? The NCLT expects us to be present in the court. We do not find competent lawyers also at times. Sorry to say that if there are some lawyers here. But some of them are not as competent. At the same time, the RP is also supposed to be doing the desk work for the regulatory. The same part which has to be done for the IPA, the same aspect has to be covered with NCLT. The same thing has to be done for IBBI. And the same set of data is given everywhere. So this kind of an administration takes up most of the time as against, what they're supposed to be doing for the company and for ensuring the revival of the company happens in the right direction. Because that should be the objective. We are actually missing the woods, missing the trees for the woods. This is what I can say. Sorry, this is just an opportunity when I could actually express myself, so I couldn't help,
Please.
when
Yeah,
everybody.
Yeah, nothing wrong, because see, I would rather say this is the forum where at least with our brothers and sisters and co-professionals, we are sharing our views. Can you share these views anywhere else? Can you share?
I wish they should have actually a forum, especially the regulatory, because today they are regulating us and they do not really know the irony or the agony that an individual goes through for running the organization and ensuring not only that their own fees get paid, because today we are into practice. And unfortunately, the bad sheep can, make what they can best, under such circumstances as against the good people who really have a good intent to run an organization and ensure that it gets resolved rather than, making their own personal gains. So it's an honest individual actually suffers more than the rest.
Yeah, ma'am. Okay, I got it. You see, what to say? Issues and difficulties in if you present in the issues are issues. That's all. You are presenting in your own tone and with your own experience. When your own experience and understanding you are presenting, same way, everybody has got their own way. They handle the things and face the difficulties. See, that's the reason I thought better to proceed before proceeding the amendment, because see, we can't simply what to say. I don't think தமிழ்ல தான் அந்த காமெடி இருக்கு. You don't understand if I say Tamil. I don't know how many of you in Tamil. Sorry, I can't translate also. In Tamil only I can say this. In one of the movie, the comedy will come. இவன் எவ்வளவு அடிச்சாலும் தாங்குறான்டா அப்படின்னு. This fellow is bearing the hit, how much ever he gets hit. Okay, so that's how the law also going that way, where this fellow can be given any responsibility he will handle. Okay, because he's capable of handling. Whether you can handle or not, no, that question is not important. That question is not put to you also. You are capable of handling. How you are telling that way? No, otherwise how 2 years liquidation period has now come down to 1 year. Then again amendment it is coming down to 180 days. Okay. But the same timeline which is there now, which is expected to do in 180 days CIRP and 270 days and 330 days, it is going up and pending for years together of 7 years and 8 years today. Okay, the law which mandates the completion of CIRP and liquidation within certain period, it is dragged to 7 years and 8 years. Now I don't know with hope that liquidation period is getting reduced. I literally fail to understand. Of course, the government wanted a better result, no doubt at all. Thing is it is that liquidator and RP is placed that way? One of our friends said, is that recognition is given to them? Is that authority given to them? In fact, the authority of verifying the claim itself now taken away from liquidator in the new amendment. The authority of verifying the claim. Okay. In fact, the earlier, the liquidator was expected to verify the claim and to adjudicate the claim. Okay, the power of adjudication of the claim, that power itself is removed now. The reason being that what is given in the report is that the claim whatever is received from CIRP, why you need a duplication? You just continue it. So that means the liquidator has to make sure that is ensuring the assets are facing all the difficulties, selling the asset and realizing and distribute whatever the claim earlier already given and got accepted or admitted. Okay. So now the powers of scrutinizing, verifying the claim also is taken away from the scope of the liquidator. And there are many changes are coming. In fact, rather I would say the RP and liquidator is given more responsibility only. One small thing is that the moratorium privilege is little getting extended to liquidation also. Earlier, it was there only for CIRP. It is getting now extended to liquidation also. But of course, that's a very small remedies coming out. But still what I'm saying, when you compare to the changes, now again it is going to go back to the hands of the CoC only. I will share you each and every amendment. Word by word, I will share you. See, I am here to express my view. Nobody can say that I'm reading something and sharing something here. No, it's my own practice. What I encountered, I know. And what's going on in the name of amendment also, I know. And how it is going to be also, I know. Meaning that how this will get practiced practically and what kind of difficulties furthermore the RP and liquidator is going to face. That also I could able to guess little with my past 7 years experience in the insolvency practice. Okay. So now moving on to that, what are the amendment? Probably when we go into much deep, because many of our friends still they don't want to share their difficulties because they are broad-minded friends, people. They want to digest everything and do best to the country and profession. Okay, that's the reason they are not sharing also, because they are capable of digesting everything, whatever happens. Anyway, you are given more opportunity to digest more after the amendment comes. I'll share you what are those amendments which are coming out, which really raise the bar of the expectation from the liquidator and RP. And let's wait and see what kind of changes which is coming across and how it is going to impact us and impact the country, impact the corporate which is doing the default. So before going into my so I have not prepared slide kind of thing because I don't want to restrict my presentation within some slide. I want to, because all are professionals. We are all past the examination. I feel proud to say, okay, we are all past the examination of IP. So at least let us go through the book and read the provision. Okay, because we are all passed, So at least let's go through the book. Whether anybody outside world, whether they are going through the law or not, book or not, or barrack or not, at least let us read so that we can give more clarity to people, wherever we encounter the issues. So that's the reason I thought, let me not give in the form of presentation, because I can't cover the entire points in the presentation. That will really prevent the opportunity from understanding the entire amendment. Let's go through provision by provision, what is there in the code and what is there in the amendment, how it is going to impact, we'll deliberate. Before that, if you want to just in a bullet point, if you want to share few things, I'll share quickly, then move on to the deliberation by with amendments. What are the amendments? See, with respect to CIRP, if you want to tell me, I could rather say that the responsibility now given to the NCLT, that don't go into the reason. Don't go into the reason. Okay, if it is sufficient, if there is a failure to pay is proved, then the duty of the NCLT is to only to pass order, not to go into the reason at all. This is made it very categorically. Of course, you all know that in Supreme Court also one of the matter it has been deliberated, probably to address that this amendment would have come. So now going forward, the NCLT is expected not to see the reason of the default. They are expected to see only whether the failure is exist or not. Failure to pay is exist or not. Default exists or not. If it exists, they are mandatorily admit them CRP. So they make it very clear. Earlier also, same way it sounds, but things were not happening, probably in the opinion of government or authorities. So again, they want to reinforce by specifically telling that that is one thing. Second thing, they also said that if you are not passing an order within 14 days, means admission it's not happening within the timeline given in the code, then the order should expressly, specifically spell out the reason for the delay. So this is the on CRP side with respect to the admission of CRP. I'll show you the provision and we'll go in whatever I'm explaining. We'll go in deep of the provisions, what language is used and what kind of the changes have come. I'll explain you in detail. Now, then next to then in the CRP, then what else is the amendments has come? And one more important thing is that the amendment to the resolution plan definition also they brought. They brought an amendment in section 5. I'll explain, show you the definition also. Earlier they amended and they introduced in amendment 2019, I remember, they introduced a word of amalgamation, merger, demerger. Now they included one more thing, that sale of non-core assets, means that also can be part of the resolution plan. That means resolution plan can have a provision for selling of certain assets, like how we do merger, demerger and compromise. Same way, it can sell certain assets also. So provision can be, means the provision can be inculcated or it can be contemplated in the resolution plan for sale of non-core assets. This important thing, corrections they touched upon in the resolution plan. Same way, the time frame for filing the withdrawal, that also they restricted. I'll show you what are those details. And transfer of asset, this is a very important thing which we need to understand. Transfer of asset of guarantor of the corporate debtor as part of the CIRP. So there are certain provisions introduced. We'll see the provisions of it. Probably I may need your input on that. Really, because now the RP is given a task of even to make sure that they are taking the possession of we need to understand that aspect, whether RP is given that task to take the possession of the personal guarantor also and see that the assets are transferred when we are as part of the plan, I'm saying. No, all this additional responsibility is given. That's why I started in the session, very beginning of the session, that our roles and responsibilities enlarged. They raise the bar and they expect more from us with the reduced timeline, with much more reduced timeline. Okay. So let's see what is their expectation. Same way, very important thing is that earlier the resolution plan, the NCLT used to give an approval in single approval, right, for implementation and distribution. Now they separated this approval part into two. First, they will give approval for implementation. Okay. Then after implementation, they give a separate approval to distribute within 30 days after implementation. So resolution plan itself is separated. Two different approval for resolution plan. One for implementation, one for distribution. The reason here being probably the failure of a resolution implementation of resolution plan. Probably government would have thought, okay, let the resolution plan get implemented, then probably the distribution can take place later on. Now the next change is this mandatory submission of financial information with the information utility by creditors. That also is they brought in. So during CIRP, I'm saying same way to initiate to file application under section 7, 9, 10. Okay. Now section 31 also is touched upon. Very important changes have been brought in section 31, 5 and 6. What is that? The same that we all know that earlier clean state principle. Earlier the Honorable Supreme Court also has given one of the matter that the new promoter should not be burdened with the old issues. So that's what the principle has been laid down by Honorable Supreme Court earlier. Now they are introducing much more thing, because earlier 31 they touched upon the provision with respect to the past offences, that the new promoter should not be made responsible for past offences and all that. Now they are improvising it by bringing in amendment, that by saying that that past liability not to be in a basis for suspending any rights or licenses. That means the after approval of the resolution plan, whatever the license or whatever the certificates or whatever the permission given by the statutory authority, all that should not be withheld, or should not the authority should not give any trouble, okay, to renewal or anything if the resolution plan is approved by quoting the past dues. So that's another important changes coming in the CIRP. I'll show you all that one by one. Then again, after very importantly that after 330 days of CIRP, after 330 days, now we are given 330 days time overall, including all what to say, litigations. Okay. Including all litigation supposed to complete 330 days time. I don't know whether it is really getting completed, because after litigation only it's getting prolonging much more period. In fact, many cases, as you know, that more 5 years, 6 years and all getting prolonged because of the litigations. Most of the CIRP liquidation matters are prolonged because of the litigations only. In my knowledge, as well as what I heard and what I come across, that only shows that more of litigation only dragging the timeline of the CIRP as well as and liquidation from completing it on time. Okay, so I think the more focus should be given how to reduce the litigation side of the code. That only probably will solve the issue. But I don't. With my reading of the amendment, I don't think anything that level has been brought in to reduce the litigation side. Litigation side is much more will be improved only. I'll tell you how it may get improved also. What are the scope to for that also I'll tell you in the amendment whatever they brought in. So when it gets improved, then the timeline falling within the timeline will be much difficult for the professionals actually. Okay. Then why I'm saying this, the 330 days time, now the apart from 330 days time, okay, even before passing a liquidation order, by NCLT in case of non-visit of resolution plan or in case of contravention of implementation of resolution plan, the provision now is getting introduced in the by way of an amendment now to give furthermore time by Honorable NCLT. Okay, the NCLT will give some more time, say that go and try to get a resolution plan within this timeline. Okay, I'll show you all that amendments and timelines, all that. That means it is going to get life again. Means the CD will get a life after failure of CRP also. That we have to say that way, right? Because after failure of CRP only application is getting filed for liquidation. Okay. Now another opportunity will be given. The NCLT today, after the amendment gets through and become law, the NCLT is given a power of giving further opportunity after failure of CRP also to further try within the timeline given in the code. Okay. So service providers of corporate data, in fact, cooperation from the personnel and other, the scope is little enlarged, but still we need to get the cooperation. That's more important. Okay, all you know that Section 19 application getting filed for cooperation from the, that itself is taking many years to dispose of. Then difficult for the RP to liquidator to even to get cooperation from the promoters and the connected person and personnel of the corporate data. Now the amendment talks about little changes in that. Means the amendment talks about little expanding the scope of the giving cooperation, means extending cooperation by the personnel of the corporate data. I'll tell you what are those aspects, what are those amendments. This is on the CRP side. Okay. And I'll take you through in much detail in CRP what are the changes come and section by section. But before that, I thought it will give a bullet point of thing, the changes, so that you'll be ready for the to see the changes, what has come, what is going to come in the provisions of the Insolvency Bankruptcy Code. What we have so far discussed, deliberated on CRP side. If you see the liquidation side, what are the changes have come? Government dues, okay, that the definition has been modified to see that whatever the judgment of Honorable Supreme Court in Rainbow Paper. So subsequently it was overruled by Panchami, that matters have been overruled, and but still the code was not amended, okay, to address the ruling of the Rainbow Paper. Now they are amended section 53. So I'm saying section 3 of subsection 31 of, or rather I have to say class 31 of section 3. It's been amended today to see that whatever the ruling of the Rainbow Paper is taken care of. So we'll see what are the changes that. Same way that the priority between the secured creditors and how it should be dealt with when they relinquish the property and when they don't relinquish the property. And same way the dues of government, section 53 1E, class E, talks about that the dues to the government say supposed to be within 2 years prior to the liquidation commencement date. So what the amendment talks is that that whatever the due within 2 days or 2 years time, that falls with the with a different priority, and the dues prior to that falls in a different priority. I'll explain you all that what are the those changes and what are the amendments have come in that aspects. And partly probably rather I should say partly secured data and partly unsecured data. This is the important changes have come. And as I was referring that this moratorium, I was telling you that whatever given the moratorium is now getting extended to the liquidation. In fact, we were earlier thinking that why liquidation alone is spared. For CRP alone, there's a separate moratorium is given. Why liquidation, the moratorium is not given. Though section 33(5) talks about no suit and proceeding shall be instituted, all that is there. But still moratorium kind of a provision was not there. Now it is getting extended. The moratorium provision getting extended, not only to CRP, now to liquidation also. So it's very important thing. Same way, group insolvency provision also is introduced. Group insolvency, what you probably many of you may be knowing that when the CRP is going on, a holding company and subsidiary whether can be brought in or not, whether CRP of subsidiary is going on or is progressing, then how to deal with the properties of a holding company, how to deal with the dues of holding company, all these things are, was a deliberation actually. Actually speaking, these are all the deliberation was going on. Now, group insolvency itself is contemplated and amendment. Let's go through in detail what is that amendment talks about group insolvency.
Sir, you have prepared any PPT, sir?
I'll show you. That's what I'm saying. I started saying the presentation that only. I am planning to take you to the provisions itself directly. I'll show you the details of it. What are the changes? What are the changes have been proposed? I'll show you the provisions. Directly, I'll take you to the provision. See, there is no understanding some group insolvency is coming. There is no point of changing, understanding that, moratorium extended. Please, let's try to understand the language, what it is used in the code. We have much time to see in a presentation style. After the code become a law, means amendment become a law, probably that time we can understand in point view. Okay. Now let's try to understand, because now the time is there, even we can even give our depreciation also, meaning that we can share our views also if anything is there. Let's directly go into the provisions, okay, rather than sticking on to the presentation. Okay, I'll just give you the bullet points now. I'll take you through each and every provisions of the code. Okay, one by one, I'll take you through the code. I want you all to see the code and what kind of language is given in the code and what is the amendment is given in the code. Means amendment, what are the provisions has been introduced in the code, is getting introduced by way of an amendment in the code. Okay. So now, same way group insolvency is getting introduced. Then creditor initiated insolvency is getting introduced. Rather taking directly in the amendment, I am just giving a bullet point. That's all. Then I'll take you through the code, or I'll quickly finish my bullet point if you are so curious to get into the code. Okay. So creditor initiated insolvency resolution process. That's a new concept is getting introduced now. So now one more thing is that and importantly now, the resolution professional, the RP, who generally used to continue as a liquidator, going forward after the amendment, it can't be expected that way. And resolution professional will not be continuing as a liquidator. The liquidator will be appointed by the CoC and with the approval of the NCLT. So going forward, that there won't be a continuation of the resolution professional as liquidator. The period when we started the practice in 2017-18, the cases and all, generally when CRP, when liquidation order is passed, the person who acted as an RP, unless opposed by CoC, they will continue as a liquidator. Now there's a change, it's going to take place by an amendment. I'll show you those changes. Okay, so supervision of CoC. It is a new provision is getting introduced. We'll discuss that also. Now, the entire liquidation is going to be with the supervision of the CoC only. Okay. Now, same way as I was referring in the beginning, claim is not getting filed afresh. There is no claim is going to be filed afresh. Because I believe that whatever the claim admitted in during the CIRP, that has to be taken directly by the liquidator. That's how it sounds. So because the provisions relating to the verification is removed from the scope of the liquidator. I'll show you the exact provision of it.
That may be the reason the liquidation period is reduced to half. There is no verification of claims and all that. Second time.
Okay.
That may be one of the reasons for reducing the period of liquidation.
So it will not take much time for verification of claims, sir. That
You
will
know,
not.
we have to call for and get, no? There was a
Sir,
time.
how much time it is reduced, sir? It is 6 months. It is 1 year, na?
Earlier it was 1 year. Now it
Now
is
they have to.
6 months.
Okay, we'll go through provisions. Don't worry. We'll go through one way. I'm not going to leave you next 2 hours. Okay, unless you switch off your system. Okay, you are going to be appraised of all amendment. Wait, let's go provision by provision. Okay, so now going forward, of course, our good friend is very positively is taking the reduction of liquidation period, but you also said that you are not handling the matter, sir. So probably if you handle the matter, you will much appreciate whether reduction is proper or not. Okay. See, in that case, if all liquidation should have got completed by 1 year, then reduction is fair. Okay.
Correct.
But that 1 year is now prolonged to 7 years. I literally, the same committee report talks about the matters are prolonged 7 years. Same committee report only talks about it. Okay. 6 years, 7 years, the matters are getting prolonged. But then what makes them to think that 6 months is sufficient, means 180 days is sufficient for liquidation? I really fail to understand. Probably anyway, the same way how we take extension, no? Yeah, for the extension of period, same way it is now. The period, if at all we need the liquidator, they need a liquidation period, they have to every time apply for extension and get extension. See, now very simple logic, you can understand this way. After 1 year, how we every time go and take extension? For every 3 months once we go for extension. I don't know. For some reason, NCLT is giving extension for 2 months, 3 months only. Okay. And so every 3 months, how liquidators are taking extension from NCLT after 1 year time. Probably after this amendment, after completion of 180 days, they have to go and take extension from NCLT by giving the reason and the purpose of the extension. All that we will anyway. We will discuss in detail why this extension. But yeah,
When the company itself goes into liquidation, generally there will be so many legal hurdles. 180 days is just impossible to complete the process. Because the claim period, constitution of CoC, that itself will take 1-2 months. And after that, that will left over is only 4 months. So if it is a small company, they may complete in 6 months. But if it is a large company, then where is the possibility? So what are the grounds they have suggested that to reduce the period, sir?
we'll discuss, sir. We'll discuss. I'll take you to all those provisions. We'll discuss. Just I'm giving a glimpse of it only. Whatever I'm telling. We'll move on in much detailed manner. We'll move on now. Okay. Now, as I was referring, 6 months is over. Now, stakeholder committee also, I don't think going forward it will be there or not. Anyway, CoC only is going to supervise and continue. See, these are the I'm saying to important changes which I thought I should share you before moving on to the amendment part. Okay, amendment part before moving to the exact amendment part. We will discuss in every amendment. I'll show you the provisions. What are the changes are contemplated to introduced to get introduced. I'll show you the provisions. Okay, then we will deliberate in much detail for each and every provisions. So these are the bullet point changes which I shared, and probably in much more I'll take you through in the bill. Okay, directly in the bill comparing to the provisions of insolvency code and okay. Till now, if anything is there, you can ask me. Otherwise, I will share my screen and I'll take you through the changes, amendments which are going to take place. Right. I'll share my screen and we'll move on now. Yeah. Any points? Okay. So I'll take you through to report, then to amendment. So finally, I want to take you through amendment. I don't want to take you through amendment because amendment will take lot more time to discuss for us to, because we need to discuss each and every point in the amendment. That's the reason I'm not directly taking you through amendment. I want you to take you through first the report and what is the opinion of the committee. Okay, I want to appraise all the points. What are the things gone through in the mind of the committee, a standing committee I'm talking about. What are the points have gone through in their mind, and what are the inputs they gave for the amendment? All that we'll see. Then we'll go and see the amendment what is proposed. Okay. While my screen is visible, can you able to see my screen? Now it's visible?
Yes, sir.
Yes, sir.
Very much visible.
Okay. I'll take you through to one by one. I'll take you through. See, this is the code I'm planning to take. I thought, okay, little, let I get these other points. See, I've got a lot of PPTs. If any of you want, I can share you. So, but my idea is not to share the PPT here because I want to more to deliberate the points, because this is an amendment. This is not something we can simply take, just take into our mind the changes, what is taking place, then practice. No, not like that. It is in the amendment stage now. So now it's very crucial stage where something we want to tell, now we have to tell the government or regulator, so that at least they will look into that. After it becomes law, nothing can be done. Okay. Probably after that amendment only, again, it can be touched upon. Okay. Now I want you to take you through a quick review on the thing on what IBC talks about, which I read in the thing. So quickly, before going into the provisions, I'm saying. See, what are the provisions? I already discussed all these provisions, okay? Cross-border insolvency. These are the basic thing what, in summary point of view, I'm giving. Okay, what they have done. In fact, this only I was telling that the standing committee presented the report on December 2, 2025. Okay, they presented. Then again it went for deliberation. Then they sent for standing committee. Then these are the main points. What are the resolution challenges and delays, cross-border insolvency? All these points are discussed. Then valuation point also has been discussed in that, and a pre-pack kind of a thing, a different manner it's coming now. Owned buyer rights, all that is discussed now. I'll take you through in reports directly to you. What is the standing committee report? Okay. See, now if you see why I wanted to show you this, you have to see what kind of a thing they are, committee is making and points they are giving, all that we have to see. And this is the detailed thing which is there. I'll show you one more thing which has got a nutshell. This is a detailed one. I have one more thing to show you. Okay, so this is the standing committee report which I was referring. So these are the members of the standing committee. So they discussed about amendments. What are the amendments brought in right from 2000? See, these are the amendments so far has taken place. Just to brush up what are the amendments have come. Okay, 2017 amendment, they brought classify the personal guarantor and all this, a second amendment, home buyers paid financial creditors and 70% to 66%. All that has come in second amendment. Then third amendment has come mandatory completion of 330 days, which I was referring also. Okay. And all this is, and the resolution plan binding on everyone. That also has come in third amendment. Then fourth amendment, all that is immunity to CD for past misdeed 32A has been introduced by virtue of the Honorable Supreme Court ruling. And fifth amendment, the suspension of initiation of the COVID-19 initiation. Then again, pre-packed insolvency as sixth amendment. Then seventh amendment, today we are. Okay. In the seventh amendment, they think these are the major, very important things: creditor insolvency process and group insolvency and cross-border process. Okay. I wanted to take you through very importantly these points. No, why I'm saying this, when we know these figures only, we can easily able to relate what are the real what is the real result output we got from the code. So this is the report of the committee. It's not my I have not prepared anything. This is a report of the committee as on March 31, 2025. Let's understand this basic statistics before moving on to the amendment. See, this is the status of the CIRP. How much is there? See, 8308, 8,000. This is status of CIRP. Okay. Closure, I'm saying. Closure by appeal, closure for approval, closure by commencement of liquidation. In fact, liquidation also they concluded as a closure only, 2007. Okay. So totally it is 8,308. Okay. Then CIRP yielding resolution plan. Okay. How many? Realization by creditor. See, 170. Then average time taken for closure. Average time taken 713. This only I was wondering. See, average time to closure itself is coming 713. For liquidation, it is coming. You see down here, average time taken for order for liquidation 508. Then how could time is getting reduced again? I don't know. Then as I was referring that now 330 days time, furthermore time is given. Not much time. They are giving very short time only. Okay. So
How much, sir?
yeah.
How much there?
Don't-
330.
We'll go through everything one by one. We'll go through because I don't want to skip anything. That's the reason I'm not giving any inputs in between. So I want to take you through all the important amendments, everything. So see, these are the statistics they gave in the. I'm showing the standing committee report only. I'm showing. So these are the inputs they discussed about MSME and what are the changes have come for MSME. All they deliberated. Okay, fine. What ended up in the form of amendment only we have to see. These are only inputs given by the standing committee. I want to show you the page number 73 here. Wait. So these are the things that we should know actually, because we are the people we are practicing. See, these are IP statistics. Okay, this is on year-wise disciplinary action taken. See, how much disciplinary action is taken? Erroring IPs. Okay, and the disciplinary committee order is issued 73 and the suspension 45. So that's why they wanted to more improvement from RP and IP and liquidator, because more people are getting suspended. 73, I'll take you through directly. 73 only talks about, I remember 73. Yeah, observation and recommendation. So these are the observation and recommendation of the committee. Okay, just to give a bird eye view only, not to in detail. Okay. See, this is the committee report, what it talks about. Okay. Importantly, they said what are the things. So efficacy and post-resolution challenges. So here the statistics you can see. Committee note that IBC has demonstrated significant success in reviving 1,322 corporate data rescued through resolution plan and a total of 8,705 CRP admitted until October 2025. Only 8,715. Okay, this is the statistics. It is officially given by thing. Okay, now this efficacy resolved the company achieving 76% increase in sale. Okay. So it is leading to resolution approximately 13 lakh crores of debt outside the formal process, with 1,154 CD having been withdrawn under 12A. Probably they would have got settled. Okay, so withdrawn. These are the statistics that they are sharing as part of the standing committee report. The committee recommends the establishment of mechanism for issuing no due certificate statutorily immediately upon completion of resolution plan. But I could not see any of the provision has come. Okay, for establishment of any online mechanism kind of thing. They only said that should not be withheld. Means the department statutory authority should not withhold. They only give the powers, for the CD, means for the resolution plan, if it is approved by NCLT, that the license should be renewed. But establishment of a transparent online system, as of now, nothing I could see in the amendment. Okay. So no due certificate and statutory clearance, all that is, I could not see come across in the amendment, but in the discussion, all that's coming out. Okay. Probably they wanted to give all that, probably in next occasion they will give all that. So delay, backlogs and judicial capacity. See, their committee itself has noted that the average timeline taken for closure of CRP is 713 days, exceeding 330 timeline. Okay. And frivolous litigation, all that is there. See, here everything is discussed. Appeals by promoter, unsuccessful, all that is there. These are the things, challenges faced by RP and liquidator. Just by just quoting frivolous litigation, committee should not stop actually speaking. Okay, committee should have understood that frivolous litigation, who is handling, at whose cost all this is happening is at the cost of RP and liquidator. It's more important that the committee should have understood. Okay, and then they have to give much more. I'm saying protection or powers and duties or little more authority should be given to the RP and liquidator. Then only the frivolous litigation can be addressed. Okay. See, credit realization, asset valuation. That's the reason recently, there's a changes have been introduced, how the valuation should be done, and entrepreneur valuation also is introduced. They have proposed also to introduce entrepreneur valuation, all that. So cross-border insolvency. These are the amendments. They stifling of fund, all that is. See, please understand, by seeing this committee report, but seeing the amendment, I don't think the amendment is directly deliberated in the report. They gave the overall views. Committee has given an overall view. But point by point amendment is not deliberated. I could not see at all that way of the deliberation with the committee report. Okay, IBC and MSME and pre-pack resolution, all that is discussed. See, committee also, they observed the outcome of PPIRP is not so encouraging. As of 31 March 2025, only 14 applications filed has been admitted. And on that, only 8 cases seeing the approval of plan. So PPRP is not really working well. That's what the committee also is. Here, importantly, see, the committee has said, like SARFASI and DRT Act, see, committee deliberates everything, but is that inculcated or that provisions to bridge the gap has been introduced in the bill? That only we have to see. We'll go and see the provision, we'll understand the provision. Waterfall mechanism and stakeholder claim, all that they discussed. I'll show you all this if you want, or it's available in the website also. Why I wanted particularly to show you, you should know what exactly the committee has deliberated and what they, and every time they conducted the meeting and they took on record and gave out some suggestion. If you see the detailed report, probably you will understand that they took a representation from State Bank of India, they took representation from Indian Overseas Bank, and they gave a letter. What are the points for improvement? All that they gave, that I could see all that. But directly all that is reflected in the amendment, I could not see. Only few is reflected in the amendment. I could not see much of that thing. I could not see. So probably we have to wait and see. But amendment is today with us. So what is going to come? Because standing committee, they gave their comment or whatever, their report, whatever we call. But today we have got an amendment which is going to become a law. Soon the Lok Sabha and Rajya Sabha both approves, and after the concurrence of the president or consent of the president, it is going to become a law. No doubt at all. We will move on to the seeing the amendment one by one. I'll show you what is there in the amendment. Also, what is there in the code today, so that it will be easy for us to understand what exactly the amendment is going to address. Okay. I'll take you through one by one because this is very important now to deliberate. Please understand, we are the people who are, there is no point of, sharing our views within this closed forum. Okay, we need to share our views outside, then only it will reach the ears of the institution and regulators. Probably some changes may come. Okay, so I'll take you through to the amendment which has come one by one. Now coming to the definition part, section 3. Okay, I'll take you through page number 2. Oh, sorry, this side. Yeah. Now, this is a very important thing which I will highlight and show you so that you will not miss out. Okay. Okay. So these are the important things which I was telling you, referring you, that we need to discuss. Okay. So see now, after that ruling of rainbow paper, okay, the government felt that now they want to introduce in section 3, okay, an explanation. In section 31, in class 31, they are inserting an explanation. What is that section 3, class 31? See this section 31, okay. In the definition of security interest. Okay. Now, because of the rainbow ruling, there was a confusion for some time. Then till Panchami's case was, no ruling was come out. No, till the ruling came out that by overruling, rather we should say, or they clarifying the position of the Supreme Court held in the rainbow paper, because the Supreme Court has said in Panchami case that in rainbow case, the Supreme Court did not have occasion to visit the provisions of section 53. That's why they rendered the judgment. So since it has not come into the judgment part, so that's what the ruling is given in the subsequent judgment of Supreme Court. By virtue of that, now the security interest definition, now the new amendment is going to come by introduction of a explanation in class 31. What is that explanation? For removal of doubt, it is hereby clarified that the security interest shall exist only if it creates right title interest claim to a property pursuant to an agreement, and shall not include a security interest created merely by operation of any law. That means The same thing in Gujarat VAT, what was deliberated in the Rainbow case, that Gujarat VAT Act was conferring, giving the position of the debt as a secured creditor. Since the law itself is giving the legal position as a secured creditor to the government authority. That's what the ruling of the Rainbow. Now the amendment is brought. The government is contemplating to bring the amendment by this way, by bringing this. They are making it very clear. Their law should not make a debt as secured one. By operation of law, a debt cannot be a secured one. A debt will be a secured one only if it creates a right or title or interest or claim to a property pursuant to an agreement or an arrangement by the act of two or more parties. So there should be an arrangement between the parties. It cannot be by operation of any law. A debt becoming a secured debt or secured creditor by default, by automatically by violation of law. So it won't happen going forward. So this is the important amendment has been brought in in the amendment bill 2025 with respect to the secured interest. Okay. Now coming on to the next amendment. Section 5. Very importantly, I need to say that coming to section 5, I skipped that. Section 9 I have come. Section 7, then section 5. Okay. Coming to section 5, what is here? See, it is very important down. If you see here, class sale or one or more. That's all. 2A. In D, class D. So this is the important thing has been introduced in the amendment, which I was referring, that a new provision has been introduced. What is that new provision? Is that already in class 26, the word merger, amalgamation, demerger has been introduced. You all know that. Okay. Now in 2A, in section 5, in 2A, sorry, in section 5, in class 26, to see in the, if you can see in the code, class 26, section 5. If you read this way, you can easily understand, and so that it will stay in our mind, after amendment becomes a law also. Now, earlier, the law as it stands today, resolution plan means a plan proposed by resolution applicant for insolvency resolution of the corporate data as a going concern in accordance with part 2. Here the explanation has been introduced. You all know that explanation has been introduced by way of an amendment, and on 16th August 2019. There was amendment brought in whereby the explanation has been introduced for removal of doubt. Hereby clarified plan may include provision for restructuring of corporate debtor, including by way of merger, amalgamation, and demerger. Okay. Here, sir, I don't understand. Many times I keep raising this point. I don't find merger and amalgamation supposed to be the one and the same. I don't know on what logic they made merger, amalgamation, demerger. They mean to say merger and amalgamation different. No, both are same. Merger amalgamation is same. Probably in section 230, 232, they are trying to say some undertaking, all that. Demerger is separated. That merger amalgamation, I don't find any separation in section 232. So, but still, for clarity's sake, they don't want to just miss out. Okay. So, for clarity's sake, they brought merger amalgamation as an amendment. Now, in addition to this amendment, now the amendment bill 2025, it is proposing to bring Not only the merger, amalgamation, demerger, and also sale of one or more assets of the corporate debtor. That means there are 3 factories are there in a corporate debtor. The resolution plan can provide to sell one of the factory, or out of 3 factories, only 1 factory. The resolution plan can provide only for that. And it can be approved also, it can be implemented also. So just like in a merger, amalgamation, demerger, how it is, same way, this also is possible going forward. It's very important. Now, coming to section 7, changes. Now, I'm sure I'm bringing to your knowledge the important changes, what is really impacting us. Okay, not that small changes I'm not bringing to your knowledge. Okay, here if you see section 7, very importantly, section, if you see the word shall, it is replaced, but now it is very important to note. Okay, what is that section 7 and subsection 5? What is substituted now? The adjudicating authority shall within 14 days of receipt of the application by an order admit. So this is very important point. How it was earlier? Not earlier, I have to say rather now. Now how it is now? Let's see subsection 5. Okay. Where adjudicating authority is satisfied that a default. See, this is a section which I was showing now. Okay. See, you could able to see the difference now. Now it starts with the adjudicating authority shall within 14 days of receipt. Adjudicate shall within 14 days of receipt of application. But how it was earlier? My God. Oh God. See the difference here. This class is completely getting replaced. It is replaced. It starts with where the adjudicating authority is satisfied that a default has occurred. That means this only gave the authority of seeing the reason, that they have to see the reason for the default. Okay, why? Because they have to get satisfied themselves. Okay, where adjudicating authority is satisfied that a default has occurred, and an application is subsection 2 is complete. There are no preliminary proceeding again proposed as RP. It may by order, may, because there was a judgment, there was a argument recently also going on in another matter in Honorable Enclave, that it only say may. So you need not to pass an order, even if there is a default. In fact, it is very interesting case recently in Honorable Enclave. You can go through, you can Google it also, because it is out of the subject, so I'm not showing it here now. But it was argued, actually speaking, in one of the Enclave recent matter I could see, where since subsection 5 of section 7 says it only give a adjudicating authority a discretionary power. Okay, that the adjudicating authority may by order admit. That means even if there is a default, still the adjudicating authority can see the reason whether it is rational or not to admit a CD into CIRP. Therefore, even if there is a default, the argument is placed before Honorable Enclave that even if there is a default exists, Honorable Enclave has got a power not to order, not to order a CIRP. So because the power is given under subsection 5 of section 7 of the IBC code, whereby it only says may. It may by order. So there is no mandate on part of the NCLT that they necessarily has to admit CD into CERP if there's a default. That was the interpretation placed in one of the matter before Honorable Clerk. But after this amendment, now that will be put on list. Now they simply brought, if you can see the same language in section 9, you can see this language. I could see this language in section 9 of IBC code that has been brought in here. And they don't want to give now any of the option to the adjudicating authority. They want to see that adjudicating authority shall, within 14 days of receipt of application, by an order, admit the application if satisfied default is existed. Default, if default has occurred, okay, and it is sufficient that default is occurred, and reject application if the default has not occurred. Okay. Now, another important thing here to see, provided that adjudicating authority, see, I'll show you here. This is very important. Such reason shall be considered. Moving on. Yeah. It shall record reason. Oh, it's 9 I have come. Okay. Here in 7 itself, I can show you. See here. These are the new provision is getting introduced. Okay. So here another point is, it is hereby clarified where record of default in respect of financial debt. I think. Okay, it is hereby clarified that where a record of default in respect of financial debt owed to a financial institution, I'll show you so that you get highlight. Okay. Where a record of default as well financial debt owed to financial recorded with institution has been furnished along with the application, and such record shall be considered as sufficient for the purpose of to ascertain the existence of default. This is very important thing. See, again here. This also important change has been brought in. These provisions are not earlier there. So they need not to record reason earlier. Now they made it very clear the reason has to be recorded. Okay, in case if the adjudicating authority has not passed an order within a period of 14 days from the date of its application, it shall record the reason for such delay in writing. So these are the important changes in CIRP they has been brought in. Okay. It shall record the reason for such delay. That means every order will have a reason only going forward. All these, because anyway it is going to, many orders are coming out after 14 days only. So that means it will have a reason for why the delay has caused. Okay. And same way, whatever the record available information utility, if it is given, that shall be considered as a sufficient for the adjudicating authority to ascertain the default. Okay. Now coming to section 9. Okay. Now again same thing is introduced here. Section 9, as you all know that an application will be filed by the OC for initiation of CIRP. Okay. So here if you see provided further, the adjudicating authority has not passed an order within a period of 15 days from date of receipt, it shall record the reason in writing. So this is very important, obligation on part of the NCLT. They have to give the reason. Earlier, there is no such obligation is given. Now, that obligation is given additionally to NCLT to make sure that they are recording the reason if there is a delay in rendering their order. Okay. See, adjudicator shall within 14 days receipt by an order admit. There is no provision that adjudicating authority does not render order within 14 days, then what is it? Now they introduce a provision saying that in case the adjudicating authority has not passed an order under subsection, then within it shall record the reason for such delay in writing. I don't know. It is going to how much, no, it is not going to improve the speed of disposing the matter, but now it gives a additional obligation to the NCLT to record the reason why it is getting delayed. Okay. Now coming to the next point. We'll go to now section 10. Same way section 9, how we have seen section 10 now. Same, whatever is I showed you, same thing here also has come in section 10. See, it shall record the reason for, because you all know that section 7, 9 and 10, all these three section 7 by financial creditor, 9 by operation creditor, 10 by corporate debtor. In all that, it's supposed to be disposed within 14 days time. If it's not getting disposed within 14 days time, then the reason shall be recorded. So it is very important timeline. Okay. Now coming to 12A. 12A is on withdrawal. For section 12A of these are the provision has been introduced. Subject to subsection 2, the adjudicating authority may allow withdrawal. There is no mandatory on part of adjudicating authority. Okay, may allow withdrawal of application admitted under section 7(9) on application made by resolution professional with the approval of 90% voting share. Okay, of committee of members in such manner. Here, very importantly, anything notwithstanding anything contained in any law in time being force. And in a time being force, an application admitted 7(9) shall not be withdrawn. This is an important change. Shall not be withdrawn before constitution of the committee of creditor under subsection 1 of section 21. After first invitation of the submission of research plan has been issued by resolution professional. So on this situation, it cannot be withdrawn. That means before constitution of CoC also it cannot be withdrawn. And after first invitation for submission of resolution plan has been issued by RP also, it cannot be withdrawn. Here also, adjudicating authority shall pass an order. Whatever it may be in an order, subsection within period of 30 days time. But here importantly, you should see that it is only a discretionary power given. May. Okay. They may allow the withdrawal, but that may they should do by 30 days time. So here also the time of application 30 days time is given. Here also same way, the reason for recording delay should be in writing. So it is not that simply while pronouncement you can say, you're supposed to say that reason for the such delay also in writing. It should be in the order. What they are trying to say that it's supposed to be in the order itself, that what is the reason for delay. Okay. Now all other amendments are routine in nature. A small, wherever there is a gap, they try to see that all that is, So here, one of the point, if you can see, section 14. In section 14, in subsection 3, okay, in class B, the expression is getting inserted. What is that subsection 3 of 14? Can we see that 14? Very important one. Sure. See, the provisions of what is that? Whatever the privilege given or protection given in the form of moratorium, okay, it is not applicable. Only subsection 3, what it says, the provisions of the subsection 1 shall not apply. Okay, shall not apply to transaction agreement otherwise has been notified by the central government in consultation with the any and be sure and a surety in a contract of guarantee of a corporate debtor. Now how it is getting amended? If you see, now it is getting amended. That means the explanation has been introduced. Okay. Now after in subsection 3 in class B, okay, expression has been inserted that for removal of doubt, it is clarified that the provision of subsection 1 shall also apply where the surety seeks to initiate or continue any action proceeding against the corporate debtor pursuant to a contract. So that means in that position also that moratorium shall apply. In case where a surety himself seeks to initiate, continue any action or proceeding against the corporate debtor. This is another important changes that we need to see. Same way, section 19. Here, I was referring, that the cooperation part, there is a changes has been introduced. Okay, any person who has been a personal promoter of the management are engaged in a contract of service with the corporate debtor. Here, if you see the earlier thing, 19. So these are the very minute changes that have been introduced. So I want to show you these changes so that it will be easy for you to relate when changes have come. Okay. And if you see subsection 1, the personal corporate debtor, any person associated with the management. It only say a promoter or another person associated with management shall extend, okay, to assist to cooperation. But here, if you see the recent amendment, okay, I will remove this. Here, if you see, it is not that a personal corporate debtor or a promoter associated with management corporate debtor or a person engaged in a contract of service with the corporate debtor also shall extend. That means who are all will come in contract of service? That means can we extend, can we seek a cooperation from auditor, an advocate who rendered a case, and any other professionals who have been involved by the corporate debtor before corporate debtor coming into CIRP? Any inputs on that? That means earlier we can't. As a matter of right, we cannot seek cooperation. We can only seek cooperation only from the employees and staff, personnel of the corporate debtor and promoter, or person associated with the management. Now with this amendment, they are bringing the service providers also. Is it not? So can a auditing service, auditor, statutory auditor and a PCS or advocate, they can be deemed as a contract for service? They are engaged for contract for service? Can you share your views on that? This we are going to, going forward, once the amendment takes place, okay, comes into effect. We tomorrow, suppose we take up a CIRP, we have to go by these provisions, no? Is it allowed? Is that the intention of the lawmakers or legislature that other service provider also should be brought in? That means engaged in a contract of service. Who are all? That means everybody can be brought in. Who are all in the service of the company. Means as a consultant or any service for this matter. Contract of service. And is there any contract should be in writing? It doesn't say it should be in writing. That means anybody has dealt with the company. Anybody was the opportunity to deal with the company and company had availed the services. It only says service. Okay? Avail the services. Then probably there also, that means the scope is extended to seek the cooperation from outsiders by RP, IRP. Okay, IRP and RP. So this is a very important thing which I thought I should share you. Here, very importantly, another section 21. The following is inserted. This is very important. Where a liquidation process of corporate debtor is initiated under Chapter 3, the committee of creditor constituted under this section shall also supervise the conduct of the liquidation process of the liquidator. Provisions of this section and section 24 shall apply to such a liquidation process. My God. So all SEC and all over now. It's going to be over. You have to open up your mouth. Otherwise, nothing going to change. You are going to enjoy. Now, already the liquidator were enjoying with the SEC. Now going to enjoy all that old COC. Okay, probably you have to wait and see all this. They can't retrospectively implement, but still going forward, the committee of creditor of CRP will also supervise the conduct of the liquidation process of the by the liquidator. So what is going to happen? The provision of this section 24 shall apply. Can you show the 24? What 24 talks? Going forward, enough responsibility is given to both. What does it mean? What does it mean? You have to share your opinion. Otherwise, after amendment has come, everyone of us will be doing different manner. Better to discuss and deliberate what exactly they try to mean it. Okay, what they try to mean it by this. The provisions of this section means section 21. Okay, section provision 21. I show you the section. Okay, the entire section is applicable. That's what it says. Where the liquidation process of CD is initiated under chapter 3, okay, the CoC constituted under this section shall also supervise the conduct of the liquidation process by the liquidator, and the provisions of this section and section 24 shall apply to such liquidation process. That means there's not much difference going to be there between CRP and liquidation. That's how my reading goes. How it goes, there is not much difference between the CRP and liquidation. It's going to be one. Okay, probably it may be called with a different name, CRP and liquidation. Stage is different, correct? But same CoC and same responsibility. What we supposed to do in 21? 21 what we supposed to do? After collation, all claim, all that, these all duties, all these are there, will be casted upon to the liquidator. All these duties are, we need to, as a liquidator supposed to comply the provisions of section 21 also. Okay, 21 talks about entire thing about how the CoC card should and what is the kind of a debt, how it should be constituted, and all that is has to be followed by liquidator. Means all this is applicable to liquidator. Okay, and not only 21. So liquidator shall make available all provisions, all that is applicable. Fine, all it is already there. The provision. Not only section 21. More importantly, section 24 also is applicable. That means the meeting of committee of creditor may meet in person. So all that meeting has to be conducted. Is it not? Please let me know after this amendment is approved and become part of the code. Okay. During the liquidation period, the liquidator is duty obligated to conduct the meeting of CoC the same manner how he is duty obligated in CRP. Is it, I'm asking you? Is it yes or no?
Yes.
At least can you say yes or no?
Yes.
Yes. So the liquidator supposed to conduct the same way the meeting how he used to conduct in during the CRP, same. So then what is the big difference that the CRP and liquidation going to have? One difference is that resolution plan, here's sale of assets. That difference alone is there. Anyway, resolution plan itself now provide for sale of assets. Then why we need liquidation separately? I'm just asking you. For deliberation, I'm asking you. Just tell me. Why we need liquidation then? what kind of difference the liquidation is going to give. Because everything what is to be done during CRP, same to be done in liquidation. Okay, I think only in
So the
addition.
insolvency professional will change.
Sorry,
The
yeah.
insolven-
Oh, that is a difference in liquidation. Oh, but process is same.
Will no resolution and it will directly the going concern stops.
Oh, going concern anyway is not there. Anyway, it's not there in the liquidation, so it going concern law concept will go away. Okay, that means managing the affairs will not be there. Is it not? That is that the difference? Managing affairs, responsibility of managing affairs won't be there.
Correct.
So that is the only difference between the CRP and liquidation after this amendment. Is there any other difference? No, much more is there. I'll share you. What are there? Much more is there.
Of course, the adjudicating powers of the liquidator have been withdrawn to a certain extent.
Yes, yeah, removed, not withdrawn. Removed. In amendment, it is removed. I'll show you that also. In section 35, they removed that. Verification, they removed. And all verification section, verification of claim by liquidator section is removed. I'll show you all that. Now, what I want to understand, after this amendment is come, let's see, there is no point, just like a movie, we are seeing the PPT and moving and closing down the system and going away and struggling on our own inside our cabin. How to deal with that, how to deal with that. Let's open out and tell. Let's open up and tell what's the solution. How we need to understand this. This is the practical thing which we are going to face. Once amendment has come, it is going to come for sure, I'll tell you. It is going to come for sure. And both amendment of under IBC and companies act, both is going to come.
So what is the difficulty you foresee here besides these points?
Sorry?
What is the difficulty you foresee here besides these points?
No, not what I am foreseeing. I wanted what 30, almost 35, 38 here. I want to get your input on that. What would be the difference? Foreseeing, leave it. I will share you many more developments, what is going to happen. In the subsequent slides, I will share you. But all I am asking in your inputs, is there any difference other than managing affairs? And going concern anyway is not that now in liquidation. Other than this and change of RP, okay. Other than this, any other difference between CRP and liquidation? Because same CoC is going to continue and same way they are going to dictate how they dictated RP, they are going to dictate liquidator. Okay, and same thing only. If liquidator is not going to listen to CoC, they are going to throw away the liquidator also. Even one request of CoC is not taken up by the liquidator, and liquidator will be thrown away.
Right.
Correct? So, what really the code is really getting improved, I'm asking. By bringing these changes, what really is getting improved? I'm asking your inputs. It's not that my inputs may be anything. I can share you my input later also. I'm asking 30 people, 35 people are sitting here.
Improvement for the CoC.
How it makes difference today? CRP and liquid. Earlier, I can easily by heart, I can say in 2017 when we started practicing, what was the difference between CRP and liquidation? By heart, we can say CRP is totally different and liquidation is totally different. It is the next episode. Totally is the next episode.
The claim process will become reduced, isn't it?
No. Leave it all claim process. That is nothing.
After liquidation, there will not be again calling for claims and all that.
I'm asking that is over. That's understood. There is no claim verification process. It is beginning itself. We understood that. What the deliberation? What supposed to be here is that what is the difference that the lawmakers or regulators foresee or see in that after this amendment has come, what is the difference that they want to understand or they understood between the CRP and liquidation, but after bringing this amendment into force?
CoC continues to monitor the things. And CoC and SEC, there is nothing much change will be there, no, sir. CoC and what do you call it, stakeholders consultation committee,
Once
both are one and the same, I think, almost.
once CoC comes, SEC will step away.
Step away.
Hmm.
So CoC continues its monitoring, which will be more effective rather than going for selecting, constituting another SEC. The time period will come down. Not to a great extent, but it comes down.
No, sir, I'm asking you why you have a different chapter. I'm asking you. Do you need a different chapter for this? I'm asking. CRP as a separate one and liquidation separate part. Do you have a separate part? Do you need?
Sir, the intention of liquidation is to liquidate the asset. Correct.
Okay.
But
Okay.
what we are discussing in the CIRB is to give the birth, continuation of that
Rebirth.
business.
Rebirth. Rebirth.
Rebirth. The intention is different. That's why it is required to be separated.
So that means the CRP is a kind of a resolution that we are trying to give. If
Correct.
no resolution, only selling of assets will happen. Correct?
Selling of assets. The intention
It
is different.
ultimately dissolution.
But now resolution plan also can provide for selling of assets partially. Now I showed you the provisions also. Resolution plan also can sell the assets, probably can revive. After that, the company can revive. After selling the assets also, they can revive. Okay. So that means in liquidation, selling of assets is the only difference is going to make. Is it not? Is there any other difference it's going to make? Selling of assets will happen. So therefore, no more resolution in liquidation. But supervision is only same CoC, same meeting, and same conditions, same dictation, and whatever ruling is same, everything is same. Correct? Only thing is here we are reviving to bring out CRP. In liquidation, we are not trying to revive the corporate data. We are selling it. That's
Yes,
only.
sir.
Sorry.
Yes, sir. I feel that is a difference.
That's the only difference today we have. Conceptually, I'm saying. Conceptually, that is going to be the only difference. Correct? So I don't know with code what intention they brought down. Now what it is going on. Probably they wanted to completely relook the entire thing. The liquidation thing itself, they want to relook the entire thing. IBC code basically how it was sounding in the initially it was different. Now it is completely sounding differently, right? Is it not?
Yes, sir.
Yes. Can you have a break of 10 minutes?
Very much.
Yes.
Yes, sir.
I don't want to bore you continuously 3 hours. Okay. We'll have a join after 10 minutes.
Yes, sir.
So we are not getting the argument.
We'll start the session again. I'll share the screen. Okay, fine. Now we'll move on to next amendment. So next important thing, if you want to, and this is another important changes as introduced. What is that? You can file an application in respect of in respect of avoidance transaction fraudulence. In fact, there's a provision now introduced that even after dissolution also, the avoidance transaction matters will proceed. Okay, the cases will be proceed. That's what the amendment is sounding actually. Here, if you see the section filing of application in respect of avoidance shall not affect the proceeding of the corporate data. Even this goes even after dissolution also, this alone will survive. That's how the amendment is come. See, for removal of doubt, it is clarified that the completion of CIRP or liquidation shall not affect the continuation of proceeding. So that means, so this alone will survive after CIRP, after liquidation. So we need to, that means the CoC has to take a decision how it should be dealt with. That's what the amendment has, has been given. Now coming to section 28, it talks about the powers of the CoC. They are introducing 28A. Very important changes is. If you read this, Section 28A, notwithstanding anything contained in this code or any, where a creditor of CD has taken a possession of an asset of PG, personal guarantor, or CG, corporate guarantor, or CD, by enforcing security interest. When it will happen? Taking possession? Generally, the bankers will take symbolic possession on the Sakfasi. They are trying to mean that only. Okay. Where a creditor of CD has taken possession of asset of the personal guarantor or a corporate debtor of CD by enforcing security interest over such asset under any law, which empowers the creditor to transfer the asset. Creditor may, during CIRP of the CRT, permit the transfer of such an asset as part of the insolvency resolution with the prior approval of CoC. That means even after introduction of initiation of the CIRP, okay, if CoC permits the creditor who has got right under any other law, suppose under SARFAESI or any other law, he can still sell the assets. So that means it is given a free hand to the creditor. Now they are given a little more free hand. That earlier, if you see section 14, it sounds that all, see, I have to show you that provisions, right? If you see earlier, the position was different. So I closed it down. My reading, my understanding is that when this, if it sounds this way, then the moratorium what is given will be compromised. Moratorium, let's see moratorium. See? Okay. Any action to foreclose, recover, enforce any security interest created by corporate data in respect of property, okay, including any action under SARFAESI. Now, see that this moratorium protection was given by virtue of passing an order under, under IBC section 14. They gave a moratorium that action should not be rendered, okay, after the initiation of the CIRP. Okay. Now, what I showed you now, it is permitting the creditor who has got right under law. That means naturally must be a SARFAESI Act, okay, or any other act for this matter. Okay. Now, if they during the CIRP permit transfer of such asset as part of the insolvency, that means now they can transfer such assets which is already in their possession. Suppose they take symbolic possession under SARFAESI, they may say that no, I have taken symbolic possession, let me sell the property on my own. So this may happen going forward. Provided CG is undergoing a CIRP, corporate debtor, corporate guarantor is undergoing a CIRP or liquidation process, transfer under section shall take place upon approval of CoC of the corporate guarantor, not the CD. Here the additional condition is that the transfer of assets shall take place upon approval of CoC. If suppose that corporate guarantor is under the CIRP, then CoC of the corporate guarantor has to be taken. So that is the amendment has been brought in now. Okay. Now coming to.
Sir, I have one question, sir, here.
Yeah, please.
Yeah, when they talk about the approval of the CoC, is there any percentages mentioned or how? Again, 66 only will come for the CD.
It's not sounding any percentage, here.
They talk only about the approval of the committee of creditors.
Yes.
Here, this one.
Yes.
Is there any percentage or how?
Yeah. This says, here it says by a vote of not less than 66% here.
Correct, sir. But but in 28A permits the approval of committee of creditors.
Here it says, okay, which impose with the prior approval of committee. In such manner, then you wait and see. Don't worry.
Okay. Okay, sir.
You wait and see. And our regulator will be coming out on how it could be done. Okay. Because
okay, sir.
Is given by, as may be specified, no, then they will come out.
Okay, sir.
Okay. So now coming to another important thing I wanted to bring it to your knowledge. Section 31. My God. Separate approval. This only I was referring. Two different approval. I was referring for resolution plan. Going forward, resolution plan is not single approval. It's a dual approval. Okay. How it is going to be? Here, first approve. Implementation of resolution plan. Thereafter approve the manner of distribution. So 2 stages. So going forward, after this amendment coming into law, okay, after this amendment becoming a law, the resolution plan approval will be in two. What is the two part? First part is implementation of plan, and second part is to approve the manner of distribution provided within 30 days time. That too within 30 days time of from the date of approval of implementation of such a resolution plan. Oh my God. Oh God. So implementation, how it will take, how long it will take? Because here it says 30 days from the date of approval of implementation of plan. Then plan how when it will be implemented thereafter. Okay. First approve the implementation of resolution plan. Thereafter approve the manner of distribution provided therein. Okay. Then within a period of 30 days from date of approval. Okay. We have to wait and see how this is really going to work. Okay. Then twofold approval. Okay. Now coming to clean slate theory which has been given. Okay. Coming to clean slate theory, here this is very important. This is very important. Okay. The clean state theory which has been ruled by Honorable Supreme Court in matter to give effect that this particular amendment has been brought in, wherein notwithstanding anything in force, where a plan has been approved, a license, permit, registration, concession, clearance, all that is given by authority. This is not something 32A that gives different thing. It gives immunity, okay, from past this thing. This is not that. This is a license. Please understand the difference between the both. Okay. Here 31 talks about where a resolution plan has been approved. The license or permit, whatever it may be, associated with that resolution plan shall not be suspended or terminated during subsistence of the remaining period of such grants or rights. So again here the protection is given that because of the past dues and other things should not get suspended. If the license is there, it should go with that license. Should not be troubled unnecessarily. So this is another clean state principle, added a clean state principle, which is in addition to the existing one. You must be knowing, already there's a provision which gives powers. Yeah. Yeah. I'll show you this. Right. I'll show you this. This also you have to see, because you have to take both together. Then only it will be easy for you to 30. I think amendment has come. Yeah. This should go along with this. Okay. This amendment, this is in addition to this. Already there's a provision is there under section 32A that notwithstanding anything there, CD, okay, the liability of the CD for an offense committed prior to the commencement of CIRP shall cease, and the corporate debtor shall not be prosecuted for such offense from the date of resolution plan approved. See, already there's a provision under 32A. Okay, the resolution plan results in change, all that. Okay, now in addition to that, and here if you see, the no action shall be taken against the property. No action shall be taken against the property or corporate debtor. No action shall be taken against the property of the corporate debtor in relation to the offense, into an offense committed prior to the CIRP of the corporate debtor when such property is covered under resolution plan. So this is to protect the property, okay, approved by the AA under section 31, which results in change in control of corporate debtor or sale of security assets under chapter 3. Okay, these are the additional protection given under section 32A. Here, one more disclaimer also is there that you have to see. Nothing in this section shall be construed to bar, because now this is taken as a important exit route for that 32A. Nothing in this section shall be construed to bar an action against the property of any person other than corporate data, a person who acquires such property through CIRP. Second, fulfill requirement against whom an action may be taken. Okay, this is one thing. Again, another one. This is also important. Subject to the provision contained in 1 and 2, notwithstanding immunity given in this section, CD and any person who may be required to provide assistance under such law as may be applicable to such corporate debtor or person shall extend all assistance and cooperation to any authority investigating an offence committed prior to the commencement of CIRP. Why I am showing this? Because now ROC office is issuing notices quoting this provision after company is even dissolved. Even after company is dissolved, and I'm saying under the IBC, I'm saying. Okay, still they are doing it because they have to extend the cooperation. That's what the provision says. So you're supposed to cooperate, you give the details, all that. Now ROC office keep getting. Recently, one of my client company also got that kind of notice. So this is very important to understand. This protection is addition to 32A, is addition to what is going to be the amendment. Okay, the amendment gives that 32A gives a protection to the property of the corporate debtor. Okay, here this give protection to the license and approval. So this is now going to be introduced in the Amendment Act 2025. This class is getting inserted in the amendment. Okay. Coming to the next one, 33. Very important thing. We have to come. Here is very important too. Okay. Section 33. This is a section of the liquidation section. Okay. Here, as I was referring, class 4 subject to the position of 52. Okay, a moratorium for the purposes referred to class A and C of subsection 1, read with the subsection 3 of 14, which shall modalities apply to the proceeding under this chapter and for the liquidation. That means whatever the moratorium, it is extended to the liquidation also. Simply they extended. Okay, under section 33, they extended. If you want, I can show you subsection 1. 4. Okay. After class 3, this is inserted. Okay. 33. So now in 33, we going for after the amendment, we will find out, we will get these provisions inserted. Along with that, we'll get this provision inserted, whereby we get the protection of moratorium for the liquidation also. But moratorium only 2 classes they refer, not entire 14. Section 14, they have not included all the provisions. Okay, let's see what are those provisions. See, they included only these 2 provisions. Moratorium A, B, C, D, right? But if you see here, they only give the subject to for declare moratorium for the purpose of referred class A and C of subsection 1. Okay, read the subsection 3 of 14. Class A. Okay, this moratorium is applicable to liquidation and this moratorium is applicable to liquidation. These 2 alone is extended to from CIRP to liquidation. This 2 moratorium is getting extended to liquidation also. Read with the subsection 3. So this continues. The same thing, exclusion is continuous. Okay, this is the important change which I thought I should share you in 33. 33 is getting introduced, moratorium provision. Okay, Okay, these are the same thing which is there in proceedings. And here, importantly, mutatis mutatis. That means however it is applicable to the situation, it should get applied. That's what it means. Okay, coming to 1A. 1A. Okay, this is another important thing that we have to see. Notwithstanding anything where they, okay, where the A is satisfied that the grounds mentioned in class A or B, subsection 1 exists, it shall before passing a liquidation order, consider an application made by CoC, okay, not less than 66%, here it is there, okay, voting share for restoring the CRP. This only I was referring, that a new life is given after failure of CRP. Okay, after failure of CRP, a fresh life is given. Okay, how much days? So that means if AA, if adjudicating authority is satisfied that the ground mentioned in A and B, what is that ground A and B? Suppose the resolution plan is not received or resolution plan is contravened, B is contravened, A is resolution not received. Okay, if that is not satisfied, and before passing liquidation order, if application is filed, okay, it can consider an application giving further restoring the CRP. It is not extension, please understand. Here the word used is not extension of CRP. That's why I wanted to give more attention to this. This is not extension of CRP. It is restoring of CRP. So CRP is over. Again, it is getting restored. After considering the application by order. By order of what? If the ground mentioned A exists, A means what? Resolution plan is not received. Restore this CRP to be completed within the period. One of our friend was asking the period. Okay. Not exceeding 120 days time. That means 180 days, 270 days, 320 days. Now 120 you can add. How much coming? Totally. Now CRP going to be 550 days. Okay, anyway, you be silent. Let me say, okay. Anyway, you are all going to enjoy the amendment. Let me also enjoy the amendment. 550 days. Okay, so going forward, CRP will not be, after this amendment, will not be 330. It will be 120 days, further time will be given and it will be for 550 days. 330 plus 120. Okay. If ground, sorry?
330 plus 120, 450.
Sorry. That's why I wanted to, you have to correct me. 450 days. Okay. Yeah, where you people are not telling anything. I have to calculate urgently and tell something. Okay. 450 days. So going forward, it will be 450 days. 330 plus 120. Okay. Now, then the CRP going to be 450 days, but liquidation going to be 180 days. I'll show you that also. Okay. If the ground mentioned in class B, what is a class B? Class B is, as I was telling, contravention of resolution plan under 33. If in case of contravention of resolution plan, okay, non-compliance of resolution plan we call it, okay, then restore the CRP to the stage of invitation of submission of plan. Please understand. Restore to the stage of invitation of submission of resolution. So this is a difference between the both. There 120 days, completely CRP is restored. Okay. Here restored, not from completely, here from the stage of invitation of submission. That means you have to start from that stage. Okay. You have to only start from that stage, provide the duration of completion of such a restored CRP not exceeding 120 days time. Okay. So totally 450. So 330 plus 120. So this is going to be, going forward, the CRP is 450 days and the liquidation is Right, I'll show you this also. Okay. Now, again, coming to explanation, here it is, see, here in this explanation, if you see, they are giving exclusion, whether it is already passed, it won't be applicable. That's what the exclusion they are giving. Anyway, it can't be made applicable. Already, if already it's going on, the liquidation progress, then certain things cannot be applied now. So they are giving that exception to the liquidation which is already in progress. Okay, shall not apply where liquidation order is passed. So already if it is passed, it won't be applicable. Okay, coming to next one. Okay, 11. Okay. Now, adjudicating authority shall pass order. This is another important change within 30 days time. Earlier, this is not there. Earlier in 33, it was not there. There was not a timeline given. Okay. That's what it was going on. Sometime argument goes on, and after a year, after 2 years, sometime liquidation order get passed. Here, this is like 14 days of CIRP. Now, similar like 30 days in liquidation. Okay. So, it will be passed within 30 days. Liquidation order will be passed in 30 days. How it is getting passed in 14 days in CIRP. So, going forward, I will see that what is going to happen. So the 30 days timeline is introduced. The another important thing. Then coming to here, this is very important provision. Provided where application under subsection 3 is made, AA, if it deemed fits, reinstate the CIRP process and pass appropriate order. Okay, this another provision is introduced in. Okay, after this, see. So they will reinstate the CIRP process also. Where application under subsection 3 is made. What is that application under subsection 3? I was showing here to you. Okay, 33. See? Subsection 3, where a resolution plan approved by A is contravened by the concerned PFA, any person other than a corporator whose interest prejudicially affected by such contravention, my God, shall make an application to the adjudicating for liquidation order. Here, there's a rider is given now. What is that rider? What is that rider? I was showing you. Provided that when application under subsection 3 is made, AA may deem fit reinstate the CIRP. How many chances given? More CIRP. Okay. Enough we can enjoy CIRP. So, are you able to understand the difference?
Yes, sir.
So, this is third person. Okay. This is third person. Okay. By who? By whom? By whom? Make any person other than corporator. Okay. Whose interests are prejudicially affected by the contravention. This is another line. So, for that, resolution plan should have got approved. That's very important. Contravention of resolution plan is different ground. Okay. Non-receipt of resolution plan is a different ground. This is a third parameter, third ground. What is the third ground? Any person other than a corporator, if any interest affected is, if that person interest are prejudicially affected by the contravention, then he can make an application. Make an application. Okay, if make application, what will happen? If he makes application, then reinstatement will happen.
Reinstate the CIRP.
But CIRP reinstatement, how many days?
120.
120.
Again 450 days. Again 450. Enjoy 450, 900 days. We'll enjoy. What is there?
There
Anyway,
is no limit, sir.
I'm not telling, no, what is there only I'm showing, no. They are not telling.
So maybe, like, of course, this is a far-fetched thought. It must be something like we complete 330 days, and then when it is to be reinstated as a CIRP, they provide us an additional 120 days. Because this is what is happening even now, where, like, the adjudicating authority is convinced that, this can be resolved. They give about 100 days of time, many which ways, in the present process also.
Leave it to ma'am. I leave it to. We have to go to like how we go to the temple. Here, the incarnation of gods are there. We have to go and stand before them. We have to see how they understand and what kind of order they are passing. Okay.
Okay.
We have to see. We don't know, but nothing is written in the law. Only I'm telling. What they understand, they will pass. Okay. They can say, as you said, the 120 days. They may say no. Start from the beginning. Also, they may say anything. They may say actually. Because here it is only may only it says. Okay, it's not giving compulsion. There's no compulsion. There's no mandatory. So it only giving a discretionary to AA. Correct? So let them. They will decide. See, actually speaking, they should have mentioned the amendment itself. They should have mentioned. Correct? But not mentioned. That means they are leaving it open only. No, because there is no outer limit given. As our friend is asking, what's the limit? Any outer limit is given? No outer limit. Then nobody can find fault on the no AA. So if he gives fresh CRP also, the word fresh alone is not used. Reinstate means bring back. Correct? At what stage? That there is no answer for that. Okay, so we have to wait and see only. But that possibility also is there. In case resolution plan is not implemented, we can reinstate the CRP. That means the entire process can be repeated. That only I'm trying to say here. Earlier, from the regime of section 33, where no resolution plan received, resolution plan contravened, that liquidation is ordered. From that regime, now we have come to this regime. Okay. Now CRP can be reinstated. So three things are there, correct? Now, there they'll give chance also here. 120 days time they are giving here, correct? So after that again they are giving reinstatement also. Maximum, they are trying to give maximum thing. Please try to use it and see company is recovered. That's what the government says. We are with a broad mind, we are giving more time to you. Please do something and revive the company. That's more important. Don't ask any relief and all, protection and all. Okay. You have every capability to handle everything. So handle it and see that time alone is given to you. Is it not sufficient to you? All time is given to you. Handle it and resolve it. Okay. Now, another important changes. This only I was telling. Now, another important thing, with a broad mind, now they brought it. Where a liquidation order has been passed, no suit or other legal proceedings shall be commenced. I don't know what is the difference the lawmakers have found between the word instituted and commenced, because earlier it was instituted. Now why they changed the commenced, I don't know. See, I will show you that. See. This they deleted, they brought here itself. They thought why there are two subsection unnecessarily. One they deleted and they brought into 6 itself that no suit or legal proceeding shall be instituted by or against corporate debtor. Now we see the difference. Now what is the difference? Here, no suit, other legal proceeding shall be. Is there any difference between instituted and commenced? Is there any difference? Now, is it going to the benefit of the government or benefit of the practitioner or benefit of the corporate debtor or benefit of the court or whose benefit it goes? Okay, why that word is not
Corporate data.
corporate debtor?
Yes, sir.
Okay, how? Because the word instituted and commenced, how it differs, what it makes difference? In what way why they have not thought of putting instituted word again here? Why they have to put a word of commenced here? Don't know.
Commencement.
Huh?
No, sir. Not getting.
You wait. They will interpret and give order, okay, for us. Don't worry. However they think they will interpret, they will give order. We'll move on with that. Okay. So now with that, this is not the only thing. Another important development in that. What is that? If pending at the date of liquidation order, please see here. There is no pendency here. It is only institution only. Okay. Under section 52 moratorium during liquidation period, only to file a fresh case, not for the continuation.
Would
Continuation
that mean that any of those cases which are ongoing under CIRP and continuing during liquidation will also be
in
under moratorium?
New amendment. Today we have to continue. Okay. Today we have to continue during liquidation. After amendment, what they are trying to say, with the broad binder, they said, no, liquidator, you will have some other work also. Actually speaking, liquidator will not have many work at all. Most of the time idle only. And so you have some work. They understood that the liquidator will have some work. So why to unnecessarily run behind that also? Let us. They understood now after 7 years only. They understood that liquidator will be with some work. Okay. Ideally, there will be some work. So why unnecessarily disturbed? Earlier they thought they'll be free only. Why continuation of work? Let them continue. No, what RP was doing, let liquidator also continue. What is wrong? The concept of realization, distribution, all that is there. But you continue to suit also. How then? Then how the dissolution will be filed? To suit is continued. I'll continue the case. I'm happy only. I'll continue the case. I will fight the case. When dissolution will happen? Then now you are giving time of 1 year time, 180 days time for liquidation. What is the use? The case will go run into years together. You want
But
liquidator.
most of the cases are allegations against the RP only or against the RP. So will they also be stayed?
What to do, madam? See, we all see. The government finding outside people are more genuine than RP community.
Somebody who's actually got the company to this stage can actually file against the RP and still stay with it.
Madam,
Whereas the RP who's actually bringing resolution to the company is the one who's at fault and is to be questioned.
ma'am, see, ma'am, RP and all, you are given training. You after giving training also you are not able to do. Promoters are not given training to run the company. That's why they are spared. What to do? Government is not giving training to promoter to run the company. They are on their own taking risk. Promoters running and giving job opportunity, taking loan, giving business to banks and all by taking loan. Okay, how much is
And taking public money also.
yes? They helping.
So much of responsibility.
They are helping. No, promoters are helping. Unfortunately, some due to some wrong miscalculation, they left the company into the liquidation. You are the person given a training. You supposed to recover it and restore it. How could you can fail?
But first of all, we are not able to recover our own dues. What about recovery of the IP's dues? That is a separate process altogether.
Ma'am, all our friends are enjoying. You alone are getting suffered, I think. See, all our friends about 30
They are probably tired. They are probably tired of stating it. So now they are just allowing whoever
What
is
is the
speaking,
use,
let them
madam?
speak.
Much more they are bringing amendment. Okay. You enjoy with the same tiredness, you enjoy that amendment also. Be tired, much more be tired, okay? Enjoy the amendments. You have to voice out. Unless you voice out, what will happen? Nothing will happen. In every session, I'm talking only, I'm telling only.
So voice, as you rightly said, should be on a certain platform. Now, where is that platform which is available to the IP for speaking with the regulator? Forget against it.
Now,
That
this
is very
committee
essential.
reports, sir, which you said, they showed us, in that they have been taken representations from IPs.
Which report?
See, actually speaking, in my personal view, if any law touched, IBC law is touched, a percentage of IP person should be there in committee, whatever the way.
Absolutely.
Otherwise, nobody knows what's happening in the ground reality. Nobody has visited the factory site. Nobody has seen the litigation, how it's going on. Nobody has received notices from different departments simply writing. Because they are getting monthly salary, government department people and all. They are simply writing, you give this, that, oh, no, you should have done this, you should have done that. No, it's not running company. No, I don't want to listen anything. I don't want to listen anything. You do this, then only I can support you. Oh, what to do? Oh, IP should come out and say something, and even in a session itself, out of 35, 5 only is opening mouth, no? Now you will get remedy. You deserve to be like this. As long as you are not opening mouth. Be like that. Okay? Nothing will change. By opening mouth, nothing will change. No. At least you have to open this for session itself. In session, in a closed session itself, you don't have a thing of opening your issues. Right? Then only it will come out. No, it will come into the light. If you tell your issues only. Otherwise, you enjoy only. Keep enjoying. Madam, what to do? I think I told you, na, madam, you only suffered more. Other friends are suffered very less. So that's why they are not opening. So let's see what's going to happen. But this is going to be the order of the day. Now, after 7 years, after lot of difficulties faced by RP and liquidator, all that, now they felt in liquidation also moratorium should be continued. Then this is supposed to have come in the code itself. How could it has not come in the code beginning itself? We were wondering by seeing section 33(5), why there is no moratorium continuation. In fact, the liquidation, it's supposed to be, should be more than the CIRP. Because liquidation is altogether separate process. Now it's different. It's going to be different after amendment. But liquidation should be isolated, actually speaking. Then only asset can be sold and distribution can take place. But here they made become employee of not employee, representative of CoC, or you call whatever you call it. We become extended arm of CoC till the pleasure of CoC. Okay, not till pleasure of CoC. Okay, as long as you are keeping CoC happy, they will keep you. If little you upset them, they will throw you out. So you make sure that you are not upsetting them, and also make sure that process you are doing properly. Doing process will not make them happy. Sometime, okay, because sometimes their interest may get affected also. If you are doing process properly also, sometimes CO's interest may get, one of the member interest may get.
They are the funders. They're the funders to the CD in the past.
Their interest get affected. So naturally, what you will do, where you may think that you are doing a process properly, but they may think that I'm affected, I'm not getting money. You are doing process. What is the use? Properly, you are doing process also. What is the use for COC? No use. You do process like this. No, liquidator RP will say, no, it should not be done that way. No, that's not our concern. We are the master. You are a servant. Because under our supervision only you are doing. When master says you do, servant you have to do only. Do, enjoy. Okay. Whatever the law says, follow it. Let's try to resolve it. Bring back the company. Because they expect more from RP and liquidator. They are not less than incarnation of God. That level government is thinking. RP and liquidator is not less than incarnation of God. So they can do anything in the world without any recognition, legal protection in the law. Of course, legal protection is there. It's given, no, 233 is there. What more you want? What more you want? That's what the government may ask RP. 233 is there, na? Protection is given to you. What more you want? Okay. So enjoy with that 233 protection. Okay, coming to next one. So section 34, here also very importantly, okay. In fact, this only is a climax, actually, okay. The committee of creditor may, by vote not less than 66%, propose RP appointed for CRP or, okay, subject to written consent or propose an insolvency other than RP, subject to written consent, such form as may be specified to be appointed as a liquidator for the purpose of liquidation. So they can decide anything, okay? And in between they can remove also, that power also is given. But still, appointment, it is now given in the hands of CoC, okay? Okay, earlier, unless objected by CoC, liquidator is appointed. Now CoC only should decide who should be appointed as a liquidator under 34. Okay. Okay. So now this is the important thing. Now coming to yes. Section 19 shall apply. This is very important thing now. See, what is this? The same thing. What is what was there earlier? Now little more protection is given. See, under section 34. Okay, I'll show you this. I was wondering what I'm wondering. After 7-8 years, almost some 70-80% of companies have come into IBC. Now, I think left out companies might be less only. Okay, almost every company has come into IBC. Every hard, what to say, promoters. We should not say genuine promoters who literally try to do something but could not do. So all those companies have already come into CRP. Little company only left out now. Now bringing all this amendment, now then the matters already before the court are decided already, and the liquidator and RP who already struggle to do the things. Then what is that? That time there was no these kind of provisions. Why belatedly all this provision? Now only they felt. Why earlier they didn't feel all this? See, this is a current provision. Currently, the provision is that the personnel of corporate debtor shall extend all assistance cooperation liquidator as may be required in managing affairs and provision section. And provision of section 90 shall apply in relation to voluntary liquidation. Please note here, this is a very important difference. The difference is that earlier, whatever the protection given under section 19 during CIRP, the cooperation that should be given to the RP and IRP and RP by the personnel of the corporate debtor during CIRP was not there for liquidation. For liquidation, only the personnel of corporate debtor will extend cooperation. Okay, in managing affairs. That too, ask may be required in managing affairs of the CD. Okay. Okay. I don't know, during the liquidation, managing affairs of CD is not part of the, for beneficial liquidation only, the liquidator can manage the affairs. Otherwise, he can't manage the affairs. Section 35 only empowers the liquidator manage the affairs for beneficial liquidation, not to run the company. Section does not empower the liquidator. Okay. Fine. Now, person of corporate data shall extend all, assuming this is the existing provision. And provision of section 19 shall apply only to voluntary liquidation. Earlier, they felt it is sufficient that protection is given to voluntary liquidation. Liquidator, they are incarnation of God. They can handle anything. Without cooperation also, they can handle everything. So they don't need any document. They don't need any support from any management. They themselves can do everything. Okay, they have every power and guidance and everything is there for them. Okay, and every now and then they are getting orders to do. So they will handle it. That's why that protection was given, not given earlier. Now, after 7 years, the government felt they are not able to really give that support to liquidators. So now they introduced this. Introduce of what? Introduce that this protection. Earlier, what they were extending to voluntary liquidation, now they are extending to liquidation also. Earlier, what was given protection to voluntary liquidation, the protection of section 19, now it is extended
Given to liquidation.
Okay. Now it is given to liquidation. That's what I'm asking. Last 7-8 years, without this itself, liquidator was struggling. How much they would have struggled? Why that level, what to say, hesitation? That level hesitation to give more, little more, what to say, benefit or it's not a kind of a privilege also. Little more arm. Huh? They can give to liquidator. Why they not stopped? I don't know. Now they felt. Now you see, now contract of service also is included. Now. Earlier it is not there. So now, not only the promoter, now promoter, associated, everything is included. Please note, earlier it is not included in the original section. Yes. In the original section, it is not included. See, it is only personal of their powers are suspended. No doubt. Okay, they cease to act. So they are free. All directors become so free. My powers are suspended. Why I have to worry? First of all, powers alone suspended. Duties is not suspended. The duties is not suspended. I don't know. Nobody voiced out that also. And promoters are enjoying. I am free. I tried my level best. How much ever loan I can take, I took loan from bank. How much ever I can spend, I spent also. Now I have no money to spend. And bank also not giving. Take it. Enjoy. Government is training one kind of a different calibered person who will revive the company. Please take it. You people again revive and give it back to us. And not, of course, again should not give back to the promoter unless it is MSME, but give to some other promoter. That's all. Okay. So they are enjoying the life. All promoters are enjoying. I don't know in last 8 years, any of the promoters literally that level struggled. I'm saying. I mean, in terms of punishment, regular punishment. I don't know. Maybe they would have punished for a few things, but that level, regular level punishment, they have known. For 1,000 crore, 10,000 crores, I have learned, we have read in the news. But I don't know anybody has suffered or not. Here we could see the list of 49 IPs are suspended. I don't know, similar way, there's no list, so how much promoters are suffered in the process. How much promoters are penalized in the process. There is no statistics in that. Probably very less only. That level, nothing is there to give statistics. But IP, the statistics is there. 49 something a number I've seen. They were, suspended. And CoC notice given. Because IPs are more vulnerable than promoters. That's how the government thinks. Promoters, unfortunately, they are not able to run the company with the money. IPs, how they can't run the show without money. They can run without money also, with the money also. Still, they are not able to do. So, government is ready to spare promoter. but not reduced for RP. Because you are given a training to make sure company is restored. Promoter is not given training to run the company properly, no. So, no, I'm just telling, this may be the understanding of the government. That's why they are sparing promoters. Anyway, what to do? It's a business decision, what they have taken. So RPs are properly guided people. Why they are not doing properly? That may be the reason why more action is taken against. So now it's extended to liquidation. Okay. Now liquidator can enjoy of taking support. Then two more application only is going to be filed by liquidator before NCLT because no promoter is cooperating. Okay. I heard also, my own experience I got also and I heard also. None of the promoters are cooperating. Okay. Protection is there. So that gives a base for liquidator to file a application before NCLT seeking cooperation of the promoter. And case also will go on for years together. Okay. So this is one thing. Then next one I wanted to say 34A is introduced. That's very important. I should come here. Oh, I can take another 10 minutes. Is it okay? I'm taking to your lunchtime. Or I can quickly wrap up. Okay.
No problem.
No problem, sir. Please continue.
Sorry?
Please continue, sir.
Okay, fine. Because it should not happen. I'm taking your lunchtime. Okay. See now, coming to section 34. This is a new thing introduced now. Okay. See, committee of creditor is of the opinion that at any time during liquidation process, the committee of creditor is of the opinion that liquidator appointed under 34 is required to be replaced. It may by vote to replace. Resolve to replace. I told you no. They will decide. They should be happy. Please, as a liquidator, please make a point. You are keeping your CoC happy. That's the main important thing that you have to keep it in mind. If you want to be a liquidator, if you are ready to come out as a liquidator, then you do your duty. Okay? Even if they are not happy. Okay? So they can remove by 66% vote. They can.
So when they are removed, that fees also goes with that removal.
Sorry?
When the liquidator is removed, his fee for that period is also gone.
Yeah, you can file an application. I think regulation, see, 31A provides for taking fees, but I don't know they will give or not. I don't know. Okay, that's $1 million question because court itself they will whether they will be giving or not. We don't know. Okay, they are asking. See, the situation is like this, where we should feel happy as a liquidator that if you are not getting punished for taking 6 or 5 years. Okay. When you are getting replaced, I'm saying. The situation is look outside. The situation looks so that after 5 years, suppose any person replaced as a liquidator, if you're not getting punished itself, you should feel happy. You are asking fees. Because they are telling you that's a blunder that you are how you 5 years you are not able to do anything. With hard-earned money, promoters have promoted the company and ran the company for their benefit. Unfortunately, they are not reap up the benefit. It is given to your hand. You took 4 or 5 days. You're supposed to be punished. If that decision is not taken, you should feel happy. You're asking fees. You are more courage to ask fees. Huh? I'll show you on provision. You see whether it will help you. I remember in regulation it is there. Provision has been by way of an amendment. It has been brought. You see whether you can make use of that provision. before they are removing it, because they will be removing it. Little something is advantageous, immediately it is getting removed. So better take action immediately, see something you can do on fees aspects, I'm saying. I remember in 31, there is a provision. When SEC is removing a liquidator can seek for fees. There's a provision is there. Okay? You can make use of it. This is liquidation regulation. Please understand, once this amendment is introduced, means once it is become a law, all this regulation will undergo complete change. Okay? So before it undergoes change, if you want to enforce anything in the regulation, please make it. Otherwise, after that, you will not get this same provision. You will get lot of surprises in the new regulations. Okay? Mm. Mm. No, here, yeah. See, this only I was telling. Today it is there. Today, there's a provision, subregulation 11 of regulation 31A of IBBA regulation. It says consultation committee, after recording the reason, for reason they have a number of reasons they can create to record. Okay, why they will not get reason? May by majority vote not less than 66% propose to replace liquidator shall file an application after obtaining consent of proposed liquidator for replacement of liquidator, provided that where a liquidator is proposed to be replaced, he shall continue the work till his replacement, and he shall be suitably remunerated till his replacement. Did you get the answer?
Sir, is there any provision that voluntary resignation when IRP is fed up of all these things, can he resign on his own? Replacement is okay. Replacement is in the hands of CoC. I don't want to continue. I want to go out.
Who is it, sir? Who is it?
IRP. My name is Pradeep, sir. I'm not. I'm not got a
Name also
membership.
no, your name also not coming. Yes.
Yes, sir. Sir, my name is Pradeep from Bangalore. I recently wrote the exam, passed, but I don't have membership, sir.
In display screen, your name is not coming. It's okay.
Yes, sir.
Oh, what you're sorry? Can you repeat the question?
Sir, is there any provision relating to the tendering a resignation by the liquidator or RP? Once he's taken a job, is there any way that he can move out?
Why you want to move out, sir? You are enjoying. That's why you are keeping quiet for whole session. You are keeping quiet. You didn't say any difficulties. Now going out alone, you are opening your mouth.
No, sir. One way we tell that IRP should be independent, and again our appointment itself and replacement in the hands of the CoC. How a person should act as independent when our appointment itself is not safe?
No answer, sir. So government has thought after much deliberation, they decided, sir. So if you are giving consent to act as a liquidator, that means you are giving consent for everything. Okay. Okay. That means you have to make sure that you are complying the law. And the CoC are independent people, and they put the money. They put their hard-earned money. CoC. Okay. They will question and they will replace. They will throw you out. They can do anything. Because their money only you are sitting. That's how the government think actually. So there is no provision.
Public money.
Sir, no, I don't know whether it's a public money government. See, you see number of the thing coming out, information's coming out. They think CoC money, CoC money. Nowhere I have seen it's sounding public money. You see the news flashing, wherever the news flashing. As if CoC money, his own money, hard-earned money. See, the fellow who has lent the money with giving a detailed loan agreement with the end-use certificate, giving all kind of inspection, checking all. Okay, in spite of that, everything that it's happening, he is not able to monitor the promoter, supervise the promoter to whom he lent money. But he will supervise liquidator who is or RP who is revise, no, who is reviving the company. Huh? If the same CoC was not able to supervise the borrower, right? They will take simply the due diligence certificate more than 5 crores company and keep it in record that everything is compliant. That's how the bank job. Oh, I don't know that. Okay.
So what you are telling is correct, sir. Because they don't properly monitor CDA and they come on us.
Sir, that's why I'm saying, sir. Today the law everywhere says CoC wisdom, CoC wisdom. Okay. Let them have a wisdom to monitor, supervise the borrower. Why that wisdom is not used on the question here? Why that wisdom is not used to monitor the promoters, wrongdoers? Why that wisdom is used only to monitor this unfortunate IPs and liquidator? Leave that 2-3 IPs are not proper. That and all everywhere, every profession, people are improper. People are there. Don't flash improper IP liquidator and even some remarks also seen that IP is liquidator. There, in every field there is there, and people are getting penalized only in every field. Court is penalizing only. How can entire community can bring it? So bank also we lost how many lakhs of crores we lost? 20 lakhs crores? 50 lakhs crores. No single banker mistake is done. No single banker has done mistake in this. In out of 20 lakhs. Correct? So we can't help it, sir. If you don't want, you have to see that you are.
No, the banks, they conduct their own way of dealing with the people who are doing wrong.
No, sir.
All that information is not available. Why should we discuss that issue here?
Yeah, correct. That's why I'm saying. See that information.
See,
Yeah.
the defaults will be there because of various circumstances, not alone because of the lack of due diligence on the part of the
No,
bank.
not in
Maybe
due diligence. Today, how it is.
monitoring also.
Yeah.
Huh.
Today, how it is
See,
monitored.
even those who have not taken loan,
Hmm.
the proprietors may be going wrong
But
because
they
of
may
various
not.
government policies.
Ah.
So suddenly this war has come, and there are so many lot of impact is there. There may be some more cases which may become NPA.
Okay.
So the other occasions are there.
Okay,
We can't blame only the bankers.
Yeah, it's okay. See, now it is completely.
And they recognized
The blame.
IBBA or the government of India, they recognized because at the time of appraisal of the loan and sanction of the loan, they are doing entire due diligence, and because of that, they will be having hold on the company's performance and all. That is the reason CoC is given the wisdom angle.
Okay.
That doesn't mean we can't blame the CoC. CoC.
Yeah, correct.
See,
There is no use of blaming, sir. There is no use of blaming. Here, sir, the forum here, what is discussed here, there is no question of blaming anyone. Here, by blaming, nothing IP or liquid are going to get. Whatever is struggle is struggle.
And one more thing is that as you have written the examination, you have chosen your path, and the stringencies everyone knows, and there are successful IPs and there are unsuccessful also. They all go
What
along.
do you determine? See, let me not get into this argument, but let us be very clear. There cannot be successful and unsuccessful IPs. We've chosen this profession for a reason, because it is of course for the benefit of the country and the economy at large. So just because somebody is trying to state that certain corrections have to be made, does not imply that the RP is not doing good in the profession, because being good is actually relative. Some people can assume that if they have made a lot of money, it's good. Some people assume that of course if they've resolved the company, it's good. So it's very relative as a concept. We are actually looking at something which is for the greater benefit of, you know, the institution as such. You know, the institution which is brought in for a certain sanctity should be used for the good purposes. So let's get back to where we were.
There's no question of argument
No
because
argument, madam. But actually, thing is, there are various ways.
no one can argue, ma'am. No one can argue. I've got 7 years practice in IBC. No one can argue. Don't worry, ma'am. No one can argue because I have practiced it. I know what it is. So it is not by reading the book I am delivering here. It's not simply by reading the book. It's not simply by reading the code. Amendment I'm not delivering here. I'm there for 7 years. Don't worry. Nobody can argue here with me. Here I'm there to tell the provisions, what are happened. What I am trying to conclude is that the supervision is always there of CoC, not only in the CRP, even in liquidation. This is the takeaway. Okay, till end supervision of CoC is there. One of our friend asked, "Can I go out?" I said, "No provision. We have no provision."
Unless he becomes very severely sick or.
No, sir. That's it. Over. 2 o'clock already. Okay, let's not give a general suggestions. We don't need general suggestion in the group at all because the IPC thing and difficulty faced by IPs. If anything is there, please share. Okay, then moving on to next one. Okay. Yeah. Very importantly, I want to cover 35. That's why I'm moving on. Because we are already 2. Okay. So now coming to this, again you see the section 35. In 35, when you see the section, it gives the power to the liquidator to verify. Okay. To verify claim all credit. But in the amendment, you see what is the amendment going to be. Right. See, in the amendment, what is going to be? They removed in 35, class shall be substituted to maintain the updated list of creditors. To maintain updated list of creditors. So that means the following is substituted. Here from to verify the claim, now it is going to be maintained. It is not I think this I can close. Okay. To verify the claim, from the regime of verifying the claim, we are going to the regime of to maintain the updated list of claim. Okay. And not only that, even in class J, the word, if you see, the invite word is deleted. That means the claim responsibility is completely taken away from liquidator. Okay. Settle claim. So here, the liquidator is given an obligation of updating the claim and settle the claim. That's only the important thing that you need to understand. Here you need to understand, okay, that liquidator is given a powers and duties to maintain the updated list, okay, and the word invite shall be omitted. Then invite word is omitted, then what is left out? If invite word is omitted, only settle the claim. So that means totally the liquidator is given a power and duties of updating the claim and settle the claim. This is a very important thing that I wanted to share with you because here, this particular thing completely changing the entire claim. Apart from that, you see section 35, 38, 49, 42 is omitted. What is that? What is the 38? What is the 38?
Consolidation of claim.
Over, deleted. 39.
Verification of claim.
Verification, deleted.
Admission.
Deleted. Deleted. 41 deleted. Okay. So there is no claim aspects, nothing going to come to the liquidator purview. Liquidator has to see that he is simply updating the claim and settling the claim.
Sir,
This is
like this, like today, like when the company is going from going into liquidation, the liquidator can receive further claims. But now after this amendment, this invitation is not there. But can he not accept any claim?
that's what it's only a question of updation only. They says you can update only the claim, not inviting fresh claim.
That means after when the
You have to
liquidation
take the CRP claim.
CRP claim, but when the liquidation order is passed, when another person comes up with the claim, he can accept that claim, although he is not invited.
That power should be given, no. They have removed, no, to verify the claim. If you accept a fresh claim, you have to verify, no. You have to verify, right? When you accept new claim, you have to verify, right? So that power is not given to you. How to take it? How to handle it?
So no claims after liquidation order.
It looks so. I'm also like you only, no.
Sir, what is that exact difference between to verify and to maintain now?
Verify means you are only accepting it. You are only seeing whether information is right or wrong and the claim is acceptable or not. All that you are only seeing. That's why earlier it was adjudication. Okay, earlier almost like an adjudication a liquidator will do. Now going forward, it won't be that way. Okay, going forward, it is only a taking, updation of record only. No question of verifying, no question of okay. So here, in addition to that, in CRP regulation, in liquidation regulation also, they are making it very clear that CoC shall supervise the conduct of liquidation process. Okay. So that means entire thing is going under the guise of CoC or blessing of CoC. The entire code will be practiced going forward. Okay. Any doubt you can ask me. So because already it's 2, I don't want to furthermore extend the time.
CoC is managing that. What is the role of SEC? There is no SEC.
I don't think it will be SEC. After CoC, after this amendment, I don't think SEC would be there. I look so.
Is there a mention of CoC also in liquidation under the new code?
Sorry?
Committee of Creditors? Is there a mention of Committee of Creditors or SCC in the new code?
Oh, CoC.
Under the
Committee of
So, by making this amendment, what the board is going to attain by just they want to replace the name with CoC. Yeah?
I don't know, sir. We have to wait and see, sir.
No,
That is a demerit because stakeholders committee is a broad representation of employees also. In CoC, there will be no employees under liquidation.
See, how it sounds is that CoC, when CoC will supervise, SEC can't parallelly exist because that will be a duplication.
no, sir. CoC is constituted in CIRP. Suppose there are some additional clients which has come in liquidation, the same CoC will continue or because what happens in normally in CoC it is only financial creditor. But whereas in SCC there are other creditors are also there. The representatives of OC is also there in the SCC. Now that OC will not be there in the CoC.
After this amendment coming into law, after this amendment becoming a law, there will be a separate regulation. There will be a complete change in the liquidation regulation. The new regulation only will answer all your questions.
But when it is going to come, sir?
When this amendment it is placed before Lok Sabha, this session should get approved. In this session, it should get approved. Already placed.
Maybe another 15 days, sir.
After that regulation, they have to amend because many places the code, the amendment says as may be prescribed. So new regulation only will answer most of our queries. Any other points?
Sir, do you think this is a good profession to continue?
Sorry?
Do you think with this kind of new amendments coming every alternative day, do you think this is a good profession to continue?
Definitely. Definitely. Yes.
They are expecting us to all
Every,
get
every
upgraded to being.
alternative day they are coming up with some new things. And this IBB and the IPA is sitting monitoring the people, and they picking up the IPs. Why
Sir,
you have not done this? Why you have not done that?
Government in their wisdom, they created a law. Okay. Government in their wisdom, they created a law. They created a practice. Okay. If you want to practice, take up the assignment and practice. Because the entire world is going to say that only to you. As a liquidator or RP, the entire world who is not getting affected is going to tell that only. The government with wisdom, they brought the law. Okay. And the training is given to you. And there's opportunity given to you. If you are interested, you practice. If you're not interested, don't practice that. So leave it. That only they are going to say. There's no other answer for this. There's no good or bad. If you are interested, you can do. If you're not interested, you leave. That's
So
it.
it is not about interest or non-interest, sir. This is about the way in which the code and regulations are being handled by the IBBA.
No answer, sir. No answer. Like you, only 38 people are here, na?
No, recently they came up with that in IBBA they want that personal guarantee forms also to be uploaded. They have put the date as 6th February and they have released it on 6th March. They have released the regulation on 6th March, but the date they have put as 6th February. What we have to think? Whether there is a delay of 30 days or whether it is a typo error by putting as 6th February.
You can directly email and write and ask them, sir. The specific questions you can write and ask them.
But it is not a specific question of these, it is a generalized question. Because they have put the date on the regulation, that whatever the amendment, that circular they have given, that they have put it as 6th February. Whereas they have uploaded on 6th March. Even today, the forms are not properly set right there. When we are going to key in that form, that is not accepting. And again, from March, they want to impose penalty also. If we don't do, they want to impose the penalty on that. So, what is your opinion on this, sir?
I have no opinion on that, sir. What are the rules we have to follow, sir?
No, we'll follow that, but first they should separate themselves, then they should come to us.
Then you should ask them only, no, who is asking you to do it, you should ask them only, not me.
It is a general form we should discuss, sir. That's what I'm
It's
asking.
okay.
I want to take another view also. Somebody may have a good idea of how this is working, how the board is working.
Enough that to discuss, sir. Enough discussed also. Any other points? Madam, can we wind up if there is no other points?
Sir, have anybody started filing this PIRP matters in the IBBA portal, sir? Any other members have already started keying in that one? I think nobody is aware of what.
No, there are too many of those forms. Probably yes. We'll take up assignments based on the fees and check the number of forms.
No, madam. IBBA has come up with a new set of forms to be filed for personal insolvency resolution process.
Yes.
So whether anybody has started feeding the forms?
Not sure.
Thank you very much, Dhanapal sir, for your nice and knowledgeable session. And participants, there is now lunch break till 2:30. You have to join back at 2:30 for the second session.
Thank you, ma'am. Thank you for patiently. Thank you.
Thank you, Dhanapal sir. You have given a very good session.
Yes.
Thank you. Thanks a lot.
Thank you.
Thank you, sir.
Yes, we can start, ma'am.
Okay, ma'am. Good afternoon, everyone. Now the session will be taken by Suhasini ma'am on the topic CoC stance in CIRP. Let me briefly introduce ma'am. Ma'am has done MCom in law. She is advocate, company secretary, and insolvency professional. She is triple gold medalist and university topper in law. She has over 15 years of experience as CS, IP, and advocate. Ma'am has worked with Jeevan Financial Services, BSc, HSC, and Broking House at Bangalore with a commodity trading company based at Singapore. Ma'am was partner with one of top IP where she worked on restructuring and companies under IBC. Currently, she is founder and designated partner at P2S Senior Advisors, who are partners with Elenco LLP, a reputed firm in multidisciplinary consulting firm, providing various services. Now I request ma'am to start the session.
Thank you, ma'am. Good afternoon, everyone. So, post lunch, we have one very interesting practical session that is about the CoC stance. So, we will try to discuss on the various important aspects of the CoC under IBC pertaining to the CIRP process. So, thank you, ICSI IIP, and a warm welcome to each one of you. And as we are celebrating today in South India, Happy Ugadi and Gudi Padwa. So basically, what are the objects of IBC? We'll just discuss the basic key objectives of IBC is earlier there were multiple fragmented laws. There was no single comprehensive legal framework pertaining to the insolvency. So now we have codified IBC with effect from December 2016. And the consolidation of all the laws pertaining to insolvency was the main object of IBC. And another object was time-bound resolution. Earlier, the resolution of the companies used to take a considerable amount of time. So to have a swift time-bound manner, that is 180 days plus extendable depending on case-to-case basis. So this is one more object of IBC to have the resolution within the timelines. Then again, maximization of asset value. So to maximize the value of the debtor's asset, which is again ensuring a better recovery to the creditors, whatever the value left in the stressed asset. So the maximization of the asset value is the main object. Then again, balance stakeholder interest. So it is again, once the company is a stressed company, NPA, declared NPA, to protect the interest and balance all the stakeholders' interest, the IBC has come into existence. Then again, promote entrepreneurship and increase the credit availability. So again, through the resolution, the businesses are fostered. This is the NPA stressed asset will be structured. That is again, orderly exit mechanisms are provided for the failing businesses. And by resolution of the company, the credit will be available in the market and the economy. So this again increases the credit flow into the economy. Then relating to our topic, one is that is creditor in control regime. So as we have been seeing the reports of IBC in various media as well as IBBI reports, we see that the ease of doing business has reduced considerably in the international because of various factors. So one of the IBC is also one of the reasons for which the ease of doing business, India's rank has come down. So this is again one of the significant outcome of the IBC. And one more important objective is creditor in control regime. So this has brought a great discipline in the market. So now the promoters, the directors who are the who were managing the corporate data, even in spite of companies going into stress or NPS, the data in possession was the main key factor where the asset value was eroding. So now with the IBC, the BLRC has recommended, and now in the IBC envisages the insolvency through creditor in control regime. So here, earlier legacy loss of debtor in possession has because of the IBC codification, now we have the creditor in control regime, that is committee of creditors. So now the corporate debtor is under the control of the creditors once the CIRP process initiates. So we know that once there is a debt and default, either the financial creditor or the operational creditor or the company by themselves, they can go for initiation of insolvency against the company. And once the application is initiated and the company gets admitted into the process under IBC under section 7 or 9 or 10, the insolvency resolution process commences. And the entire process is run by the insolvency professional who will be appointed as IRP or RP under the control of the committee of creditors. So again, we have seen CoC is widely dealt subject matter under IBC under various forums like NCLT, NCLAT or the Supreme Court. So here in the Supreme Court and New Metal versus Satish Kumar Gupta, it has held that CoC is a creature of the statute and an instrumentality of the state. So here Supreme Court has clearly said that the committee is created out of the statute and they are again the instrumentality of the state. So when we go back and look about the committee of creditors, this has evolved through the BLRC. So once we refer to the BLRC report, which is headed by TK Vishwanath, who was instrumental in designing the IBC. Here, a core recommendation of the BLRC was the establishment of the committee of creditors, wherein the shifting the insolvency regime from debtor in possession to a creditor in control model. So once we see the basis from where the IBC has come through the BLRC report, we see that the core recommendation was the creditor in control. So through this, the CoC of the corporate debtor is one of the crucial pillars in the CIRP process, who duly aid and duly support the RP in the resolution process. So again, the IBC, we see that it is a time-bound process. So it is a time-bound mechanism. So when it is time-bound, you need a seamless functioning. So when you need a seamless functioning, you need a direction or the decision-making authorities to be very swift in taking the actions, and there should be a proper authority or proper mechanism wherein the process is run in a seamless way. Hence, we have the CoC who will be supporting the RP in running the entire process. So once we have seen the basis for the committee, who are the committee? What is the definition of committee under IBC? If we go to section 2, subclause 1D, committee means the committee of creditors who are constituted under section 21 of IBC. So when the company gets admitted into CIRP, the role of the IRP starts. He gives a public announcement and he writes to all the creditors who are the creditors of the company as per books of accounts. That is as per mandated as per the IBC code and the regulations. Within 3 days of the commencement of CIRP process by NCLT order, the IRP will give the public announcement, and within 7 days, he has to write back to all the creditors as per the books of accounts whatever the data or information available with the IRP. If he is able to get some information from MCA portal or from the management, so he has to write back to the creditors about the commencement of process, and he has to he has to request the creditors to submit their claim. Whatever claims they have against the company, they have to submit the claims in the respective forms, prescribed forms under the CIRP regulations. That is Form B for operational creditors, Form C for the financial creditors, Form D for the employees and the workmen. And we have Form E also. That is again authorized representative of the employees. And we have one more form that is for the other creditors. So in the prescribed forms, they have to submit the claim. The claim has to be submitted by the creditors to the IRP at the specified address given in the public announcement or by email to in the prescribed form, along with the document substantiating their claim. So the claim has to be substantiated by an evidence of document which establishes that they have a claim against the company. Then once the claims are submitted within the prescribed period, that is within 14 days, once the claims are submitted, then our IRP will verify the claims, and within 2 days, he has to constitute a committee of creditors with the unrelated financial creditors of the company. So if you say who will become the members of committee of creditors, they are the financial creditors who are unrelated parties, who are unrelated to the financial creditors. They form the committee of creditors. So IRP has to form a committee of creditors, and he has to file this report with the adjudicating authority. And within 7 days of forming the committee of creditors, he has to have the first CoC meeting. So again, if we see section 18 of the code, it is the duty of the IRP to constitute a committee of creditors based on the claims received. And also he has to determine the financial position of the corporate debtor. And as per section 24 subclause C 6 of the code, each creditor will be assigned a voting share. So if you see the voting share, what is voting share? Voting share means, say suppose we receive 10 claims from financial creditors. That total claims, what is the amount? Claims received and what is the claims admitted. That means after verification of the claims, IRP will admit a quantum of amount as admitted, and each the entire claims, whatever is admitted is treated as 100, and whatever is the admitted portion of that respective financial creditor, that will be their voting share. So that voting share is very critical when it comes to the voting during the CIRP process. And also in sometimes when the distribution is proposed based on the voting share, hence voting share, many sometimes many creditors also litigate if the IRP has admitting highest amount of claims of any specific financial creditor. So going forward, I'll share some of the practical examples which we have faced during the CRP processes, as well as some case laws. So here voting share, assignment of voting share is very critical. So this is, it determines the voting rights of each financial creditor. So when we have seen the definition, it simply said committee of creditors are who are constituted as per section 21. So what is section 21 says is, IRP will, after receiving all the claims, he will collate and he will determine the financial position, and he will constitute the committee of creditors, and he will file a report certifying the constitution of CoC. And when the creditor who submits the claim after the stipulated period in the public announcement, but again before 90th day of the insolvency commencement date, then committee IRP has to, RP or IRP has to include them in the creditors and verify the claim and then admit the claim based on the validity of the claim. Then we have new amendment also which has come in, which says that the creditors can submit their claims up to 7 days prior to the committee of creditors voting on the resolution plan. That means whenever creditors submit the claim just before 7 days when the CoC goes for voting on the resolution plan, till that time, that is after this 90th, up to 90th day, there is no need to RP to go to CoC. RP can verify the claim and include in the list of creditors and reconstitute the committee of creditors if any additional claims have come. But even sometimes in RP, what they does is financial creditors submit the claim, but whereas some portion of the claim will be kept under verification because RP may need some clarifications. So pending clarifications from the creditors, RP can, after receiving clarifications, RP can again revise the voting share and also revise the list of creditors and reconstitute the CoC with the modified voting rights. This also no need to go to CoC to revise the list of creditors or the voting share. But however, after 90th day, but before 7 days before voting on the resolution plan, if the claims are submitted, then RP has to treat it as admissible or non-admissible. If it is admissible, if it is non-admissible, he has to inform the creditor that it is non-admissible, hence they are not considering in the process. Whereas if it is admissible, RP has to prepare a list of all admissible claims and he has to go back to the CoC and take their voting and file an application before the adjudicating authority for condonation of delay in filing the claims. So this is how, till the process concludes, this is how the constitution of CoCs happen and the voting shares keep changing. Then who will be the members of CoC? Members, always the committee of creditors are financial creditors of the corporate debtor, and where the corporate debtor owes own financial debts to 2 or more financial creditors as part of consortium or agreement, each such financial creditor shall be part of the CoC and their voting share shall be determined on the basis of financial debts owed to them. Say suppose there are 2 or 3 financial creditors who are part of consortium. Then each consortium member will become a different committee of member of CoC and they will be assigned different voting shares. So here, as we have been discussing, the related party will not have any right of representation or participation or voting in a meeting of the CoCs. But however, this condition is not applicable to financial creditor regulated by the financial sector regulator. If it is a related party of the corporate debtor only on account of conversion of substitution of debt into equity shares or convertible into equity shares, then completion of such transactions as may be prescribed prior to the insolvency commencement date. So if we see here, relating to the related party only for the financial creditors who are regulated by financial sector regulator, for them there is an exception. So if we see in NCLAT in Jet Airways case, it held that if parallel insolvency proceedings has been initiated against the corporate debtor, then the respective authority of other country has also right to participate in the meeting of CoC and joint CIRP will continue in accordance with the IBC. So if there are parallel proceedings, there were parallel proceedings in Netherlands and in India against the corporate debtor Jet Airways. So the respective authority of other country also will participate in the meeting of CoC. So when a person is a financial creditor as well as operational creditor, so under section 21(4), if a person is both financial creditor as well as an operational creditor, such person shall be financial creditor only to the extent of financial debt by the corporate debtor, and they will be included in the CoC and will be given a voting share proportionate to the financial debts admitted or owed. Then for the operational debt, to that extent, they will be treated as the operational creditor. When during the process, if an operational creditor has assigned or legally transferred any of his operational debt to a financial creditor, then that assignee or transferee will be considered as an operational creditor to that extent of the assignment.
Please could you come back again to that foreign directors' participation in CoC?
Yes, sir.
Previous slide, yes.
So in the Jet Airways case, there were parallel proceedings running. One was in Netherlands and the other one was in India. So in this case, the right to participate in the meeting of CoC, there was a joint CIRP which was going in this case. So in that case, the RP in India will attend the proceedings of CoC in Netherlands, and the Netherlands RP will be attending the meetings of CoC in India. This was a joint CIRP. Hello, sir. Hope I'm clear.
For that part, I was just thinking that that CoC has been Supreme Court has passed judgment that CoC is an instrument of the state. So now when foreign people will be participating in CoC, and then that will be also an instrument of the state. That's what I was wondering.
Sir, with this cross-border will coming into existence with the new amendments, new code. So all these things will be settled, sir.
Okay.
So even during the CIRP process, in case there is an assignment of debt, the assignee will step into the shoes of the financial creditor. So when there is a consortium agreement or syndicated facility, where the terms of financial debt are extended as part of a consortium arrangement or syndicated facility, providing for a single trustee or agent to act on behalf of all the financial creditors, then they will authorize that trustee or agent to act on behalf of the CoC to the extent of their voting share. So in my case, what has happened, we had 10 NCD holders who were represented by IDBI trustee, and on behalf of all the NCD holders, the IDBI trustee was the agent who was acting on behalf of the NCD holders. They were representing in the CoC. Or otherwise, they have to appoint a insolvency professional at their own cost to represent them in the CoC. But however, if the trustee agreement provides for them to act on behalf of the NCD holders, then they can represent in the CoC meetings. So they can exercise their right to vote to the extent of the voting share of that specific individual financial creditors. So even security or deposit holders are financial creditors. They will also be included in the CoC. In my case also, we had the ICD holders who has given the ICD intercorporate debts. Some companies have given ICDs to the corporate debtor. So they were unsecured creditors. They were forming part of the financial CoC. They were unrelated parties. So we need to ensure that the CoC is not constituted by the related parties. So when it comes to class of creditors, we have to see at least 10 financial creditors are creditors in a class. They are constituted as a class of creditors. Here we see home buyers mostly. So they will, in the public announcement given, the IRP has to give 3 insolvency professionals. The class of creditors, you have to see the majority of them where they are residing. From that place, you have to choose 3 IPs and recommend in the to the adjudicating authority, and after the approval, the details have to be shared with the class of creditors, and they will the adjudicating authority will appoint, and they will be appointed as authorized representatives on behalf of this class of creditors. So with the Chitra Sriraman Supreme Court case, now it is clarified that the home buyers are also financial creditors. So committee with only operational creditors. We have been discussing who constitute the CoC, that is only the financial creditors. Now let's discuss committee with only operational creditors and no financial creditors in CoC. This is dealt in Regulation 16. So where the corporate debtor has no financial debts or all financial creditors are related parties of the corporate debtor, in that case, the committee will only consist of members who are 18 largest operational creditors by value. If the number of operational creditors is less than 18, the committee will include all such operational creditors and one representative elected by all workmen other than those workmen included under Regulation 18 of the operational creditors, that is these highest 18 operational creditors, and one representative elected by all employees. So workman employee 1, employee representative 1. Then this member of this committee shall have voting rights in proportionate of the debt due to such creditor. Again here the same criteria of debt due. They will get the voting share. So again, the committee formed under this section, this regulation, also they will have the same rights, same powers, same duties and obligations like as if the CoC is constituted by the financial creditors. So here, if suppose when the committee is consisting of only creditors in class, in that case, the authorized representative will be the committee member. So when we are discussing about the committee of creditors, the decisions of the committee of creditors are taken by way of voting on the agenda items which are put up before them. So majority of the cases where it is pertaining to running the process like eligibility criteria, evaluation matrix, or on the approval of the plan or liquidation or approval of the cost, or the matters which have to be exclusively dealt by the CoC, there it is 66%. Otherwise, for approval of CIRP cost and other matters wherein 66 is not prescribed, the CoC will take a decision by way of 51% voting share. And for only one case, that is withdrawal from the process, it is 90% voting share. The CoC has to approve the decision for withdrawal from the CIRP process. So when we are discussing about the CoC, what is the CoC stance and all, we will discuss what is the role of the committee of creditors. So basically the main important duty of CoC is to bring the resolution of the company or go for liquidation and protect the interest of all the stakeholders and to maximize the value of the corporate debtor and ensure that they protect the interest of all the creditors, and they ensure that they have to ensure that if the corporate debtor is a going concern, they have to support RP in the managing the operations of the CD to keep the CD as a going concern, or otherwise assess the viability of running the operations. if it is viable to run the operations, or what kind of optimum level of operations to be kept, or is it better to close the operations or run the operations at what levels. Then one more important is also ensure that subsidiary operations. So in my case, I was managing a corporate data which was a running concern, whereas it also had two subsidiaries which were 100% subsidiary of the corporate data. And the CoC knew that the company had no land and buildings, no plant and machinery. They only had some projects from the various government authorities as well as from big companies. And these projects were very critical for them. And the subsidiary, 100% subsidiary of the company also had very good projects. So the CoC was very interested in also monitoring the operations of the subsidiaries. So when the resolution applicants were proposing the resolution plans, they were able to negotiate and do a very good marketing for getting the resolution for not only the company, whereas in the resolution process, strategically, the shares of the subsidiaries are also transferred to the SRA. So in this case, what the CoC was interested, they used to monitor the subsidiary company operations also, so that the CD is kept, is not the CD subsidiaries are kept as a going concern, so that it will be value maximization for the creditors. Then CoC is the supreme decision making authority in the CIRP process. So decision making is by voting. Many times the decision making authority of CoC was reaffirmed, and the judiciary has held that the scope of commercial decision making authority of CoC is very limited scope of judicial review. And as per the BLRC and the IBC, CoC is the ultimate decision making authority. Hence, the many appeals were dismissed which were challenging the decision making authority of the CoC. So before going on the plans, I would like to just discuss how the process runs and what will be the CoC stance. So even the business decisions in the process is also the foray of the committee of creditors.
Please come to CIRP cost, previous slides.
I will take it up, sir. I have not taken it. I'm just going in the sequence.
Okay.
In the sequence. So we have discussed how the CoC will be constituted, and at the first CoC meeting, the RP will place all the agendas pertaining to the right from initiation of CIRP till the constitution of CoC, and how he has taken over the control of the assets of the corporate data management operations, as well as what is the as is where is current position, financial positions, operation position of the corporate data, so that and what is the cost which he or she has incurred till the first CoC meeting. Along with that, whatever are the CD specific issues, whatever the IRP has identified, all those agendas have to be put up before the CoC meeting, and it will be 30th day. So within 30 days, the first CoC meeting has to be held. So based on the agendas put before the CoC will take a call on how the operations are running, what is the way forward on the CIRP process, and RP will always keep the timelines chart before the CoC, stating what is his or her action plan to cover the timelines and how they are going to proceed in the process. And one important role which comes between the first CoC and the second CoC is valuation. So valuation and preparation of information memorandum. So these are two very critical duties of RP, which comes between 30th to 68th day. So what is the role of CoC in we discussed about the operations and viability of running the operations, and CoC will take the commercial decisions on the interim finance requirement also. If there is a requirement of raising any interim finance, CoC will take a call on the whether to raise the interim finance or not. So what is the notice period for calling the CoC meeting? It will be usually 5 days, but again CoC with their approval, they can reduce it to not less than 24 hours. So as per IBBA guidelines, the CoC, the latest amendments, CoC has a role in valuation now. Last year, 2 years back, there was an amendment wherein the IBBA has amended the regulation saying that the valuation methodologies adopted by the valuers has to be discussed at the CoC meeting, and CoC has to get themselves clarified what kind of methodologies the valuers are adopting in valuing the CD. So here the CoC, what is the role of CoC is to discuss the methodologies. In my case, the company had only security financial assets. So the projects which the CD has specific. So only in the entire market, the similar industry, there were only one or two companies to compare to prepare the projections for those companies. So valuers, based on the projects, based on the receivables, based on the future projections, they prepared the valuation, and the draft report was presented to the CoC and the methodologies were discussed. And here I appreciate my CoC members. I had 53 CoC members in my CRP process, out of which 13 were financial institutions. And in that 13, 5 were financial private sector NBFC or private banks. So they were very aggressively participating in the valuation methodologies, what valuers were adopting. So the valuation numbers were quite different, and also the assumptions and the projections prepared were quite complicated, and complex things were discussed between the valuers and the CoC. So actually the CRP would have completed within framework of 9 to 12 months. It was a large size CD. But for the valuation and transaction audit, it took close to 5 months, because the methodologies and the discussions between the CoC and valuers and the draft valuation reports discussion took close to 3-4 CoC meetings. And the CoC meetings had the CoC members widely discussed, because we had a different CoC members. So the contribution from the valuers and the CoC was really exceptional. The discussions were very critical. And when the valuation was finalized, just before the valuation was getting finalized, this amendment has come. So we had to comply with the IBBA guidelines. So we invited the CoC for on the valuation methodologies, and it really helped. It really helped in assessing the right fair value and liquidation value of the corporate debtor with the wisdom of the committee. And the CoC members were actively participating in the valuation meetings also. And again, the valuation, these valuations are the benchmarks for comparison for the valuation, fair value liquidation value with the VAP, the plans received during the process. Then again, CoC will use these valuations to compare the resolution plan value. Again, this is basis for payment to creditors, especially the dissenting financial creditors under section 53. This is again benchmark for the resolution plan bids. So when it comes to, then after that, the next role is information memorandum. So when the role of CoC is limited, but however, if RP needs any help or any documents from the committee, any members of committee of creditors have any data or information, RP can ask from the CoC and the IM can be updated. The IM has to be issued to the committee of creditors and also to the prospective resolution applicants. Then comes the expression of interest. So in the CIRP process, the main purpose of the process is to get the resolution for the company. So here the expression of interest is issued in Form G, inviting the resolution plans for the resolution of the company. So here the authority is again the CoC to whether to approve, whether to go for expression of interest or not. So here again, if in the EOI, if the resolution plan is not approved, then again CoC can issue a fresh EOI. But again within the timelines. So again we have regulation 36A1 where RP has to issue EOI. Yes, sir.
Only I want to look for some information memorandums for the companies who are already going through this process. Where can I find?
You want to see the information memorandums. Sir, usually it is a confidential document which is given to, which is provided to only the committee of creditors and also to the prospective resolution applicants of that specific corporate debtor. And if you submit an EOI only, you will be getting the access to that. But however, if you want any formats, many are available in the market, sir, information memorandum. Now, I am also part of IBBI committee where now IBBI is bringing formats for all the process documents like information memorandum, evaluation matrix, RFRP, and the format of resolution plan. So shortly we can expect IBBI will publish the formats for all this. So usually information memorandum is nothing but what are the contents of IM is already there in the regulation, which says the assets as on CIRP commencement date, liabilities as on CIRP commencement date, and who are the creditors as on CIRP commencement date, and what are the legal cases, and why the company has come into stress, and any other information which RP feels that is important for the resolution applicants to take the decision for submitting the bid for this company. Just a minute, sir. Sorry, I'll just share once again. So we were discussing the expression of IM. So IM will constitute the assets, liabilities, the position of the corporate debtor as on CIRP commencement date, the legal cases, and whatever RP feels are critical and important for the prospective resolution applicants to take decision for submitting the bid. Sir, hope I'm clear, or you want any?
Yes, I was just thinking like for academic purpose, like what are things like how information memorandum is written or that.
Okay. So in market, many formats of IMs are available, sir, with the insolvency professionals. So valuation, we have discussed, and information memorandum. Then expression of interest also we were discussing that within 60 days of commencement of the process, the IRP or RP has to issue the Form G expression of interest. Then again, in Form G also, a detailed expression of interest document has to be prepared by the RP, which the CoC will run through and they will approve. Each CD is different. So in detailed EOI, what happens? Sometimes the CoC is suggesting to have some kind of benchmark for the prospective resolution applicants to submit the plan. That means, suppose if it is a pharma company, or if it is a manufacturing company, then they will try to provide the net worth requirement. So the person who is submitting, the person, individual, company, or consortium, or any party who is submitting the expression of interest should have some kind of net worth criteria as on some specified date, like previous balance sheet or some cutoff date. CoC will prescribe. And sometimes, in majority of the times, what is happening is no serious. Sometimes they just want to collect the information. They'll submit the EOI. So to attract the serious prospective resolution applicants, CoC will prescribe a refundable deposit. So if you are they will prescribe some refundable deposit. This is all again not mandatory. It's all commercial decisions of each CoC. They may prescribe some refundable deposit also. So these are all conditions wherein a detailed expression of interest, all the details will be provided, wherein the cutoff date to submit the expression of interest, what are the conditions, what is the format in which they have to submit the application. Also, they have to mention they are not ineligible persons, as per section 29A. So all these details will be very detailedly discussed by the RP in the CoC meeting, and the CoC will take a call based on the specific to the CD, and that will be approved at the CoC meeting. Then we have the evaluation matrix. So usually after issue of expression of interest, what happens? The prospective resolution applicants submit their bid, and once they submit their tender expression of interest, then the required documents or whatever are the requirements by the prospective resolution applicants, like visit to the corporate debtor facility, or they want to come and meet RP and try to understand what exactly the CD is into, what are the assets current position, and any issues they want to understand, they will come and discuss, and they'll submit the bids, and they also submit the plans. But if we, in the process, if the RP and CoC receives more than 2 or 3 or 5 resolution plans, then it is difficult to have the evaluation of the plans and decide who will be the L1 or L2 and who will be the final successful resolution applicant. So here the main evaluation of the plans received in the CIRP process will be evaluated based on the. Yes, sir.
When these prospective applicants come to the RP, asking all these details, can they ask for copies of documents?
Yes. Yes.
RP is bound to provide.
Sir, what happens? We will create a VDR, virtual data room, in the mail, And we will save all the information memorandum, evaluation matrix, RFRP, and all the documents in that drive, and that link will be shared with the prospective resolution applicants for doing their due diligence at their end.
Okay.
Yes, sir. So when 5 or 10 or 2 or 3, any numbers of resolution plans come, then it will be difficult for the CoC and RP to evaluate the resolution plans. So they have to choose the best resolution plan. So here the committee will, RP will prepare a evaluation matrix, which is quantitative, qualitative evaluation of the bid which the company, the resolution applicant submits. So usually quantitative is purely on the financial terms, like what is the net present value of the plan offered, what is the tenure, what is the tenure of the financial proposal, so and what is the current market value. All these qualitative parameters, quantitative parameters will be given highest marks usually, and then mostly it will be 75 to 80% they'll fix on the quantitative parameters. Then comes the qualitative parameters where they'll give 20 marks usually or 15 marks. There they will see the experience or expertise or of the promoters of the prospective resolution applicant, or what is the experience in the same industry where the CD is operating. So all this will be evaluated. That is the feasibility, viability of the plans evaluation, and the CoC will record the deliberations on the evaluation criteria of the plans received. Then comes RFRP. So when the expression of interest is given, RP and CoC will decide on the evaluation matrix criteria. CoC will approve the evaluation criteria. Then also the request for resolution plan document will be approved by the CoC. So here what is RFRP is? RFRP is a document which a very detailed document how the resolution plan has to be submitted to the RP and what are the terms which are mandatorily to be contained in the resolution plan, and it will detail how the process of resolution plan to be submitted, what are the timelines, and how, evaluation matrix also is covered in the RFRP. So in this there is again performance bank guarantee has to be provided for implementation of the plan. So again, this is CoC will discuss and they will approve whether it will be 15%, 10% or 20% of the bid which the resolution applicants going to submit will be the performance bank guarantee. And also in RFRP, they have to provide how the avoidance transactions has to be dealt after the approval of the plan and how the proceeds are going to be distributed from the avoidance transactions, as well as in case if the corporate debtor is a going concern, CoC will decide a cutoff date how the proceeds of the revenue from the going concern will be shared, whether it will be distributed to the corporate debtor, whether the proceeds from the operations will go to the corporate debtor or it will be distributed to the creditors. So in my case, what has happened, the CD was a going concern, it was generating revenue. So we didn't know when will be the date for approval of the resolution plan, because we know when we submit the application to NCLT for adjudicating, we will have some tentative timelines, like within 3 months of application or within 6 months, the plan may get approved. But sometimes it may take a long time. So what CoC will decide is, in case the company is going concern running operations, they will fix a cutoff date up to which the revenue from the CD will go to the committee of creditors and thereafter to the corporate debtor. So here in this case, the 30th September was the cutoff date which CoC decided to put the cutoff date for for sharing the proceeds from the operations of the company. And after that cutoff date, that will go to the company. So here in this case, the proposed timelines for us were, we were proposing to submit the resolution plan application to NCLT in August 2024. So CoC decided 30th September as cutoff date, but it took again 3 months for NCLT to approve the plan. So by December, the plan was approved, and I have handed over the company in January, but the cutoff date for deciding on the sharing the operations revenue was already decided in the RFRP by CoC. So here again, the CoC has the absolute right to negotiate with the applicants regarding the amendment of the RFRP. Again, the RFRP can be amended only once. And if RFRP is amended, again we have to give 30 days time to the prospective resolution applicants to submit the plan. But however, the authority is with the CoC. So this I have already explained regarding the claims of CoC. In case claims are received just before the 7 days, CoC votes on the resolution plan. So CIRP has to be completed within 180 days plus 90 days can be given extension under section 12. But again, extension of CIRP period is also the stance of CoC. CoC has to take the decision whether to extend the CIRP period and run the CIRP process, or if they want to go for liquidation, they can go for liquidation. Even the exclusion application for the CIRP period, in case if there is litigation, if CIRP period is extending, that is also the CoC has to approve for making an application for exclusion of the CIRP period. So again now, last few years back, there was an amendment. So now the CoC has to, there was a lot of concerns by the RPs and CoC members also, when till when the CoC meetings have to be held. Some used to tell till the approval of resolution plan. Some used to tell once the application is submitted, no need to have. But now there is an amendment which says that, which clarifies that meetings have to be convened till the resolution plan is approved or liquidation order is passed. Then again, that convening intervening period is 30 days. But however, each CoC between two CoC meetings 30 days. But however, CoC can also increase that time period more than 30 days. So when we are discussing about the importance of CoC and we are coming in a sequence how the process runs, there is a very, very important section 28 of IBC, which is mandatory CoC approvals are required to RP is the ultimate authority in the CIRP process, but again, with the approval of CoC only, certain actions have to be taken up in the CIRP process, where CoC approval is mandatory, or otherwise that entire act becomes void ab initio. That is, raise any interim finance in excess of the amount as may be decided by the committee of creditors in their meeting. Suppose RP wants to raise any interim finance. If CoC decides only 1 crore will raise, then RP goes and raises another 2 crores. This is void. CoC can go and complain against the RP with IBBI and NCLT. So RP cannot raise any interim finance without the approval of CoC and create any security interest over the assets of the corporate debtor. So during CIRP process, RP cannot create any security interest over the assets of the corporate debtor without the approval of CoC. So in my case, what has happened, the company was going concern, which was running in various projects. During CIRP, one of the project has, the bank guarantee has come up for renewal. Then the business was increasing. So the vendor has asked for enhancement of the bank guarantee. So now to give enhanced bank guarantee, the bank was asking for some FD, some security. So there was revenue which was generated from the company operations, and the bank has asked for 1 crore FD. Now, when we want to give this 1 crore as a security, I have to create security interest, and bank is asking on FD to create charge. Then I went to CoC. Then CoC was not willing to give the approval. Then to keep the company as a going concern, you need this project. And you need this project means you have to renew the BG. So if you are not renewing the BG, then the project will close and the value of the CD will drastically will come down and the resolution plan will get hampered. These all were explained and sorry.
Yeah, madam. One doubt.
Yes, sir.
Yeah. Good afternoon.
Yes.
Suppose the CoC for constituting CoC, it takes some time, 21 days after, isn't it? So meanwhile, it is a going concern. If the resolution professional or IRP wants to avail any interim finance without there being no CoC, uh, they have to approach adjudicating authority or somebody, or they can avail subject to CoC, somebody, one of the CoCs who are interested to give, or if they want to go outside for borrowing, is it possible?
Sir, it is always advisable because within 30 days, first CoC meeting will be held. So you mean to say before that 30 days, it is very
Urgent.
to run the operations and urgent. In that case, I suggest it is better we can go for NCLT adjudication. But by the time application comes up for hearing, you will have your first CoC meeting.
No, in such a situation arises, how to handle it?
Sir,
That is all practical problems. But if
Sir, maybe theoretically we can answer, but practically if it comes, even if you go for a interim finance for a company which is admitted into CIRP, in market you won't get good response, sir. In our case only, I'll explain. One poultry.
But some cases, for some technical reasons, it may be entering into CIRP, which has to be, the operations, everything are good. For some fault on the part of the somewhere, suppose some OC is filing a case, operational creditor, there is no default in case with a financial creditor. In such case, what is to be done?
Sir, all that we can do is we can make application to the existing banker and then again wait. We can explore whatever options are available, like make application to the existing banker as well as you can make an application to NCLT. But by then you will have your that 30 days time will come.
Okay.
Yes. Thank you. Then in our case, so that FD has to be created. Then CoC members were not agreeing. So one of the CoC member only gave the BG. So they also insisted that charge to be created on that FD also. But in ROC, what has happened? ROC, once you file INC 28 and it records that the process is under CIRP, it was not allowing us to file any of the forms for creation of charge. Until this creation of charge happens, bank was not willing to give the BG. Then we went and we made an application before NCLT and we went and met ROC for filing the CHG2 form, which was not happening. What we did, we filed GNL2 form with all the attachments of creation of charge and then uploaded on the NCLT portal and we requested on the MCA portal and we requested the bank to give the BG that we have genuinely.
1 minute, madam. It is the duty of the financial creditor to create charge, not the RPs, no?
Sir, it is the duty of both to create the charge.
I think I feel
create any security interest over the assets of the corporate debtor. In this case, on the corporate debtor assets, the security interest is being created, sir.
Okay.
Then change in the capital structure of the corporate debtor by way of issuance of any additional. That means you cannot increase the capital or issue any, can have any corporate action like buying back or redemption or issue of securities without the approval of CoC. You cannot change the ownership of the corporate debtor, like changing the shareholders, and give instructions to financial institution maintaining the accounts of the corporate debtor for a debit transaction from any such accounts exceeding what was decided by CoC. So you cannot give instructions to any of the bank accounts where for the debit transactions that amount will be already decided. If decided by the CoC, you cannot give instructions beyond that amount. Then undertake any related party transactions. So here, in my case, there was a subsidiary which was asking for a loan for submitting a BG for a project. So that was a related party transaction. So I bought in before the CoC for their approval with 66%, for which CoC has not approved. So amend any constitutional documents. That means you want to amend any memorandum of association or articles of association, you cannot amend. Then delegate authority to any other person. Suppose RP wants to delegate his power to any other person. You have to take CoC approval with 66%. But even then, I feel IBBA will come and take disciplinary action if you want to delegate. So don't do that. Then dispose or permit the disposal of shares of any shareholder of the corporate debtor or their nominees. Then make any changes in the management of the corporate debtor or its subsidiary. So in my case, again, the subsidiary wanted to change one of the director during the CRP process. Again, they sent me the EGM notice. That same item I have taken up before the CoC for their approval. And if suppose CD is having any financial rights or any rights on any material contracts, if RP wants to transfer other than in the ordinary course of business, that time also need to take mandatory approval of the CoC. And even any changes in the appointment or terms of contract of any personnel as specified by the committee of creditors. Suppose you are going to change the statutory auditor. This is also very important. During the process, if you want any statutory audit to be taken up and you want to change the existing statutory auditors or you want to change internal auditors, then also you need to take the approval of the CoC. Even when you are appointing an auditor, yes, sir.
The fees also approval, that fees part.
Yes, sir. Make changes in the appointment or terms of contract. That is terms of contract also. So whenever you are appointing or making any changes in the fees for internal auditors or statutory auditors, please go back to CoC with 66% approval only you take up.
Valuers fees, CoC approval is required.
Valuers fees is again CRP cost, sir. It is 51% only. Yes, CoC approval is required for the cost. Yes.
No, the appointment of registered valuer also need to be approved by CoC here, since
No.
registered valuer is not mentioned here.
Sir, appointment of valuers is not mandatory CoC approval. RP has to appoint the valuer. Only the cost of valuation need to be approved by CoC with 51% voting.
Okay.
So we were discussing about the CRP cost, sir was asking. So many times adjudicating authorities have, in many multiple applications, they have allowed the applications filed by various stakeholders, especially RPs, and directed either applicants or CoC to pay the CRP cost. The cost which are again approved by CoC and which are legally enforceable. So CoC has to approve that CRP cost, and those are legally enforceable against the members of the committee who has participated in the decision making process. So when CoC participates in the decision making process, it is their duty to approve the CRP cost and pay the CRP cost, regardless whether they vote in favor of or whether they have abstained. So again, the tribunals have again cautioned against the use of procedural delays and from the financial creditors. So again, here creditors cannot benefit from the process while evading their financial contributions. So tribunals many times they have held that the creditors are taking benefit of resolution process, but they are evading the financial contribution towards the CRP costs. So here, as CoC is the ultimate authority either to approve or ratify the CRP cost, usually what constitutes CRP cost is RP fees and his expenses and interim finance, then going concern cost also to keep the company operational, then all the professionals cost and legal and other costs. Then the 1% of the fees on the payable to the professionals, that is also IBBI cost, CRP cost only.
Madam, this public advertisement cost is also CIRP cost now?
Yes, yes, sir. Yes, sir. So when we will discuss few case laws regarding the CoC. So there is a latest case law on the Think and Learn Private Limited. This is that Byju's, whether what is the legal character of the CoC. Here the CoC was the Section 9 application. The CRP commenced against Think and Learn Private Limited. And CoC was constituted with 4 members only on 21st August 24. And even RP has filed the application before adjudicating authority for constitution of CoC. But however, within 10 days, the RP again reconstituted the CoC by removing 2 financial creditors. That is Glass Trust LLC and also Aditya Birla Capital. So on the date of constitution of this revised CoC, the earlier applications regarding was yet to be formally taken on record. So what happened? 21st August itself, that application was not went to the bench. Then again, RP has filed the 31st August reconstitution of CoC, removing 2 names. So what happened? The Glass Trust and ABCL, they filed separate applications challenging their removal. Then adjudicating authority has allowed both the applications. Subsequently, on 17th February, the adjudicating authority, they allowed the earlier applications relating to the original constitution of CoC. So what adjudicating authority did is they admitted, they took on record the constitution of CoC, but again reconstitution, removal of these 2 people, they have not considered, they dismissed. So then this reconstitution has become infructuous. Then again suspended directors, they went and filed an application for removal of Glass Trust from CoC. Then again, adjudicating authority dismissed the application of these promoters on 2 grounds, that CoC does not have a legal character and can only be represented by the RP. So here, what has happened? The removal of 2 CoC members was challenged by the 2 creditors. Then adjudicating authority dismissed the application, stating that CoC does not have a legal character and they have to be represented only by RP. And again they said, since the application in question was directly essentially against the Glass Trust, the CoC is not a necessary party to the proceedings. So adjudicating authority dismissed their application, saying that CoC is not a legal character and only it has to be represented by RP. So now the CoC members preferred an application before the appellate authority. Now what was the observations from NCLAT was, the appellate tribunal examined the legal character of CoC in the context that they have implemented themselves into the proceedings for seeking removal of the financial creditors. Here, the tribunal again, what they did is they noted the issue regarding the examination of whether CoC will possess a distinct legal character, juristic personality, or whether it can litigate on its own name under the IBC code. So again, although CoC is a statutory decision making constituted for the purpose of CIRP, it is not a permanent body and it will come only for the specific insolvency proceedings. So here the appellate tribunal considered the question of legal status of the CoC in the statutory context. So again, what NCLAT has held is they recognize the CoC functions as a collective body of financial creditors, and they recognize that they play a very crucial central role in the resolution process. But however, they cannot implead as a legal character or together. So here the rights of the creditors on individual basis are affected. So it is essentially the inter se rights. That is not the entire CoC rights. So accordingly, NCLAT has held that whether GLS Trust should continue as member of CoC is again a issue that concerns only the concerned creditor. So it is not a collective right. It is not conflicting the entire interested groups together. It is only for the specific purpose, and that specific creditor has to go and file the case before the authorities. So here if we see the legal character impleading the CoC is not upheld. When the individual rights of the creditors are affected, they have to go with the individual application. So this we were discussing, we'll discuss the case law. Can a resolution professional raise interim finance from a related party without formal approval of CoC on the specific terms? So if we see the latest case in Religare Finvest, what has happened, the interim finance of 1 crore only overall the RP has discussed with the CoC in the first CoC meeting, where RP has not taken any steps to seek the consent of the CoC on the specific terms of the interim finance. Whereas he just mentioned at the first CoC meeting, there is a requirement of 1 crore without any specific loan terms. But after the first CoC meeting, the withdrawal proposal has come. And for 15 months, there was no CoC meeting. And RP went and took the interim finance from the related party. And he also appointed related party as the legal counsel in the case. So here what has happened? After in the second CoC meeting, RP has recorded in the minutes that the interim finance approval was given. And Religare was the only single CoC member. Then again in the second CoC meeting, City Union Bank has joined as the CoC member. So City Union Bank was not part when the interim finance terms were discussed. So RP has not brought to the notice of the CoC about any agreement for the interim finance. What are the terms? What is the agreement entered? Nothing was brought to the notice of the CoC, and he has taken the CRP interim finance to run the process. And out of the CRP cost incurred, interim finance raised, 97% of the interim finance raised was used for the purpose of paying the RP fees, advocate fees, and very minimal 3% was used for the operations. So here what has happened, the CoC submitted, CoC filed a case against the RP. Then what RP has submitted is, RP has submitted, he has discharged all his functions and obligations. He has disclosed the interest of the related party. in the IBBA as per IBBA circular. And also he has bought the first CoC meeting minutes wherein the CoC member has approved for going for 1%, 1 crore interim finance. But however, there was a withdrawal process. So all this he bought in, but again, Religare has what is the Religare's point of contentions was RP has taken the interim finance, that too from a related party at an interest of 15%, and again further default interest of 2% without approval of CoC. Here, first CoC meeting, they have only just authorized him to take the interim finance, whereas the structuring of the interim finance was never discussed. And even when the CoC meeting minutes were put up for approval, Religare has clearly sent an email to the RP conveying their disagreement on the minutes of the CoC. But however, RP has not bought this in the Religare's submission through email conveying their disagreement on the minutes was not recorded in the second subsequent meeting minutes. Then, when the bench went through the minutes of the first CoC meeting, it did not reflect the final terms. Although CoC has voted in favor of the resolution for interim funding, but the resolution only authorized RP to avail the term interim in general terms, not like in specific exact final amount and final terms, wherein the interest rate, default, nothing was discussed in the
Yeah,
at that
in
point of time.
principle approval he has taken.
Yes, absolutely, sir.
Yeah.
Then again, there was no CoC meetings. After that meeting, 15 months, he has run the process without intimating anything about the utilization of interim finance. Then all are related parties. So what NCLAT has said is, out of 64 lakhs interim finance, then this matter went to liquidation. RP has submitted his claim before the liquidator. So NCLAT has held that the liquidator shall pay an amount of 50 lakhs only to the interim finance provider for a period of 30 days from the date of the order. And the balance amount has to be refunded by RP to the liquidator within 30 days. And also they have found that there are a lot of professional misconduct on the part of the RP, and they have referred the matter to IBBA for initiating appropriate actions. So out of whatever the taken as interim finance, only a part of it the court has given specific orders to liquidator to return to pay the interim finance provider, and the remaining has to be borne by the RP. Then when we are discussing the main CoC stances where they can take the decisions, so all the commercial decisions for running the process, for running the operations of the corporate debtor, it is again the RP who has to take the commercial wisdom from the CoC. But the main important crux of the CoC role comes, yes, sir.
Well, this fees being very contentious issue, ideally, after you get an assignment, when should this fees be discussed with the CoC and get approved? At what?
Sir, at the first CoC meeting itself, you have to fix the IRP fees, and the CoC will again appoint same IRP as RP, or they will appoint another insolvency professional as RP.
First meeting only everything has to be done.
First CoC meeting, yes, sir.
Thank you.
Yes, sir. So section 30 subclause 4, this is the main primary role of the CoC. That is, CoC has to either approve a resolution plan, or they will after considering the feasibility viability of the resolution plan, either they will approve the plan by not less than 66% voting rights, or they will go for liquidation. Then again the CoC has to consider the mandatory requirements in the resolution plan before approving the resolution plan. So the mandatory contents of the resolution plan are provided under Regulation 38 of the CRP regulations. And they have to consider whether the plan is a feasible and viable plan. So whether, and also the manner of distribution proposed. So again, the priority has to be checked whether it is as per section 53. And the priority is based on the value of the security interest, or some precedents are there based on security, value of the security, or on the voting rights. So it is again the commercial wisdom of the CoC on the distribution. So in during the CRP process, if still time is left and invitation of resolution plans is possible within that timelines, CoC cannot go for liquidation. Then again, protecting the safeguarding the interest of the assets of the corporate debtor, the role is also there on the CoC. Suppose assets are there and RP is requesting the CoC to approve the cost for engaging a security guard. And CoC is not approving. If you are not engaging security guard, then there may be theft or there may be issues for the protection of the assets. So it is again the responsibility of CoC to ensure that the assets are properly safeguarded. Then initially, not only initially, even now, the CoCs will not send the authorized person who will be able to take the decision at the meeting. Although many amendments have come, CRP regulations are amended, circulars are issued, even then members of CoC will send someone who will only attend the meeting, will not take the decision, who will not be able to take the decision on voting. So here, in some case laws, it was held that members of CoC should give authority to those nominative representatives who should be able to vote at the meeting, or for smooth voting process he should support. So I want to discuss one or two practical cases here. In many cases, what happens, the CD is a going concern and large companies. Suppose if we see here, Gayatri Projects was a very big EPC company which was running projects across India and with thousands of employees. And also Carvi, which was running various projects where close to 12,000 employees were there. And just CRP gets admitted on some cutoff date. Say suppose 20th September or 15th September or 10th January, if the CRP gets admitted, what happens to those prior CRP period, the 10-day salaries? Employees will come to you. 10 days, you will say you have no authority to release the 10 days salaries. And operational creditors who are mandatorily required for running the company, who supplies goods and services. You will not tell, you will say that your bill is for 30 days. You supplied these goods services for 30 days. I'll bifurcate into 20 days and I'll pay you only for 20 days. 10 days I will not pay. So like this, lot of issues have come after the CRP process commenced. There was huge
Those for those days, I think they need to submit claim to the
but practically, you see, employees.
because that is also due as on the date of CRP commencement date.
No, madam, these are all ongoing costs. You have to pay even for 10 days and 20 days. Even previous dues also you have to pay, because these are all ongoing costs.
No.
You cannot differentiate that I will not pay 10 days. You have to pay.
Sir,
If you keep the CD as a going concern, you should pay them. Only the supplier bills, those things you can bifurcate, but employee dues, you have to continue.
Agree, sir. I'm just coming to that point. So what has happened is, in these cases, RPs, what they have done is they went to, in my case, I'll just bring, I brought to the CoC notice that some of the employees, majority of them are in the range of 20 to 30,000 salaries only. So for survival, they need to survive. They are asking for full month salary. I went and asked CoC, can you approve as CIRP? Because they said, no, we don't have authority. We will not approve. You go to adjudicating authority. So that to the tune of 1 month salary was close to 1 crore. If you bifurcate for 10 days, it was coming to some 15-20 lakhs. Then employees were not happy. So I have to run the process for next one year, 12 months. If they don't support, we cannot run the process. So what I did is we went to adjudicating authority and we took the approval and then we paid the salaries. Similarly, in few cases, sir, as we were discussing, IBBA has imposed disciplinary action against RPs if they have paid prior CRP cost initially. They have imposed 5 lakhs penalty on one RP, sir. There is a disciplinary order. They have paid the salaries for that prior CRP 1 month salary. So with as a best practice, it is better that always you keep the CoC informed and also take adjudicating authority approval and pay the such operational cost, which is mandatory for running the CD as a going concern. So we'll discuss in many cases, we have seen majority of the webinars, we have heard that the many cases CoC commercial wisdom was upheld. So what is commercial wisdom? What is feasibility, viability? I'll just discuss in some case law this was held. So commercial wisdom are the legality issues which are specified under section 31 of the code. So here, what is the commercial wisdom is the feasibility and viability of the resolution plan. They have to see the elements of the evaluation matrix and how the distribution of amounts between the classes of creditors and what is the classification or differentiation among various creditors and what is the undertaking, how the undertaking is going to run, and what is the going concern proposal from the successful resolution applicant. And in case it is opting for liquidation where there is no resolution plan, whether the operations are stalled, whether the operations will be revived under the resolution plan. So all this have to be considered mandatorily for feasibility and viability. So what are the general factors for gauging the feasibility? What is the sufficiency of the capital structure of the PRA? And what is the earning power of the business? What are the economic conditions? And what is the ability of the debtor company's management? And what is the probability that the same SRA management will continue? And what is the value and marketability of the corporate debtor assets? And what is the possibility of impact of the debtors company's ongoing civil litigations? What is the regard, especially this is pertaining to the receivables. And what is the prospective availability of creditor and what is the financial ability of the prospective purchaser? And what is the availability of provision for sufficient cash flows in the plan? So all these are the few general factors of feasibility which are being given by various adjudicating authorities in the feasibility and viability. So we have been discussing in many cases, many Supreme Courts have upheld the commercial wisdom of the CoC. But let's discuss one or two case laws where the commercial wisdom of the CoC was not upheld. So if you see in the Micro Capitals Private Limited versus KSS Limited, here the NCLT said that the plan was not approved since it lacked a realistic revival model. So here in this case, what has happened? KSS Limited, which had its resolution plan, was sent for the approval to NCLT, where the plan was going to pay to the creditors and put the company back on the track. These were the two proposals. But when NCLT went and closely examined the plan, they found that the most essential legal requirement for the revival of the company, excuse me, sorry, any questions, sir?
No, no, no.
Okay, sorry. So here, what has happened? The NCLT went and checked whether the main essential legal requirement of revival is possible in this resolution plan. Here, the SRA was an NBFC. They were boasting of financial experience, and they have proposed a plan for revival of the corporate debtor. But however, bench held that it is not a feasible plan. The tribunal again, they realized that there was no roadmap on the implementation of the plan. The candidate is simply mentioning about his experience, and bench has clearly remarked that there is no operational roadmap in the plan, and how the business activities will be revived, restarted. There is no mention about that, and there is no step-by-step strategy for turning around the company, and no projections, no viability analysis was provided. This is only just assumptions, assertions were given without any proper feasible and viable plan. And also they have recorded, they have noted that the CoC has never deliberated on the feasibility and viability of the plan. This was a red flag. And also the regulation 38(3)(b) and section 33, subclause 4, the tribunal has completely scanned the entire CoC meeting notice. And they, CoC meeting minutes, and they found no evidence on the feasibility and viability. So usually nowadays what's happening in the resolution plan approvals, NCLTs are asking to submit all the CoC meeting minutes. And they are also going through the Form H. So even in Form H also, they didn't find about the revival of the viability of the revival of the CD. So NCLT went and said that the section 30 subclause 2 violation was identified. And also the plan was not mentioning about any payments to the dissenting FCs. Hence, the NCLT dismissed the plan as it is not a realistic revival model, and there were no statutory and regulatory payment of the creditors. If you see in this case, I think there was no mention about the payment of statutory payments also. So when we are discussing about this, even CoC earlier, before the Jet Airways case, and not even the, yes, sir.
Madam, is it not a duty of a resolution professional itself, before he table that proposed resolution plan before to the CoC, he need to check the content of section, all the section, that important material of the resolution plan. It is his duty, correct?
Yes, this is duty. In this case, what has happened? Nothing was discussed, nothing was minutized, nothing was reviewed in the resolution plan. CoC also approved, RP also filed, but bench has observed all this.
Okay.
Yes, sir. Yes, sir. There is a question from someone, home PC. Yes, sir.
Same, madam. I clarified it. It was it a resolution professor should have taken care that the content of the resolution plan.
Yes, sir.
Okay. It is missed out. Okay, madam.
Yeah. So in majority of the times, what is happening in the resolution plan, the benches are asking 4 or 5 standard questions, sir. One is about the feasibility, viability discussion, and also the whether the plan is, although there are precedents, but many benches are asking whether the plan is less than the liquidation value, and also on the viability of running the operations, and they'll also see the source of funds and the viability of the successful resolution applicant, whether he will be able to implement the plan successfully. Source of funds also sometimes they are asking. And in a staggered plan, I was part of a resolution plan where the SRA has given a staggered plan for 2 years. So their bench had apprehensions on the implementation of the plan. They suggested on the board of directors, let the representative of financial creditor be there or RP. So they have sent back the plan to CoC for their consideration of the conditions. CoC said no, as a representative of FC to getting the approval from to be on the board, it is not possible for them. As an RP, I also said that I can't be on the board of CD. So NCLT said, okay, if you record in the CoC meeting, it is not required, then that is fine. You submit the memo. We'll take the recordings of the CoC proceedings and then we'll approve the plan. So again, in another case, that is Sandeep Maheshwari versus State Bank of India, here NCLT disapproved the plan being not accompanied with the required analysis of feasibility and viability. So here, listed civil construction company, which was under Section 7, several plans were abandoned by number of applicants, but eventually one plan was approved by CoC, then RP approached the NCLT. Here again, bench held that no feasibility and viability of the plan was discussed, and they found that basic requirement of regulation 38 mandatory requirement was not complied with. Hence, they rejected the plan. They also mentioned that the Form H contained incorrect statements. So there were incorrect statements in the Form H. It was mentioned that the feasibility and viability of the resolution plan was discussed at the 15th CoC meeting, whereas when the bench was going through for the 15th CoC meeting minutes, there was never CoC discussed on the feasibility and viability of the resolution plan. So as we are discussing about this important case of feasibility and viability, also we see that there is a latest discussion paper which is proposed by the IBBI, wherein now it is mandatory for the CoC to record why they are approving the plan, what are the reasons, what is the criteria. And earlier they used to write only some 2 or 3 lines, but now with this discussion paper, IBBI is expecting even they are putting a lot of onus responsibility on CoC to record thoroughly why they consider and approve this resolution plan, what are the various terms, why they consider it as feasible and viable. So it's going to be a different, after this amendment comes, it's going to be altogether a different way of minutizing the minutes, and even the CoCs have to be cautious in the recording the feasibility and viability on the of the resolution plans. Even in the same case, not only the misstatements in the Form H, the tribunal also found that the PF dues and statutory liabilities were not addressed in the plan. Like Supreme Court has clarified that the PF dues, how it has been dealt, 100% has to be paid. All those have not been considered in the resolution plan. Hence, NCLT rejected the resolution plan, stating that CoC did not evaluate the feasibility, viability, and also the statutory obligations of government dues not considered. Hence, the plan was rejected. No, they have not upheld the commercial wisdom of the CoC. This is also one important judgment where the resolution plan was not approved. Here, during the process, a nominee director has submitted a resolution plan. But again, CoC has rejected his plan, but again he went to NCLT. NCLT dismissed his application, saying that here again a different case, commercial wisdom of the CoC is upheld. So a nominee director was disqualified under section 29A. Hence, CoC rejected the resolution plan. in some cases, the commercial wisdom of CoC can be different. Although currently I don't have any case law details here, NCLT Bangalore has approved a resolution plan where CoC has approved the resolution plan. SRA has proposed 1 rupee recovery to the creditors, but for the revival and completion of project, he has provided a huge money as a resolution plan proposal. But however, NCLT has approved the resolution plan based on the commercial wisdom of CoC. So here in Supreme Court in Maharashtra, seamless, the doctrine of the commercial wisdom was upheld, wherein the committee has approved a plan which released the assets of the resolution company in favor of resolution applicant at a 20% value less than the liquidation value, because the resolution applicant was infusing more funds into the company to keep it as a going concern to make up the loss. So here the commercial wisdom of CoC is upheld, although the value proposed was 20% less than the liquidation value. So in another case of Karad Urban Cooperative Bank versus Swapnil Bingar Dev, here the Supreme Court has again refused to get into the committee's evaluation, that is again commercial feasibility and viability of the plan. Here there is a snag, there is a issue in one of the plan terms, which was in the knowledge of the CoC as well as the successful resolution applicant. They have taken a conscious, well-deliberated decision to proceed with the approval of the plan. Hence, the plan was approved by NCLT and NCLAT has upheld the same. Even Supreme Court has refused to interfere on the commercial wisdom, even though there was a snag in the one of the aspects of the resolution plan. So again, CoC cannot approve a plan which is illegal. So here in one of the case, MCGM versus Abhilash Lal, the plan was approved wherein the leasehold lands of the corporate debtor were dealt with and proposed to be commercially exploited without the consent of the landowner. So here the approval of the resolution plan by CoC was set aside and it was held as illegal. So even in Committee of Creditors Satish Kumar Gupta, the resolution plan which was extinguishing the surety's liability in a unilateral manner without the consent of the creditors, the courts have held this is illegal and they have struck down. So if a plan proposes for extinguishment of a contractual liabilities of a third party without that party being informed, then that plan is also not legal. So here the issues of legality in the resolution plans has to be checked, ensuring that the whatever the resolution process, resolution plan approval process stays within the limits of the approval of contours of the laws. So what are the stances, what are the provisions of creditors' rights are there? Creditors can go for initiation of the resolution process. They can go for withdrawal. They can extend the time. They can issue the expression of interest, provide the eligibility criteria. Then all the process going concern and also approval of the resolution and even the distribution mechanism also to be dealt by the creditors in the resolution process. So even in Swiss Ribbons case, where we have seen that Supreme Court has held that timely effective resolution of the debt, corporate debtor is critical and the related issues also to be dealt by the creditors, and the protection of creditors' right are very critical. Hence, Supreme Court has upheld the constitutional validity of IBC and emphasized that financial creditors should always have the primacy in the resolution process, given their expertise for assessing the financial feasibility and viability. So we have seen many times adjudicating authorities keep sending the resolution plans back to CoCs for considering certain terms which they feel that they have to be reconsidered. So here what Supreme Court has held that the objective of such revisions should only have to ensure that the plan is meeting the requirements of the insolvency and they are not violating any of the rights. However, the court should not ask for alteration of the resolution plan terms, giving benefit to only to one of the resolution applicant. So even in case of where the creditors decide giving less to the dissenting creditors, again in India Resurgent Amit Metallics, the Supreme Court upheld that CoC has the authority to approve a plan that gives dissenting creditors less than the others. This is again commercial valuation. This is one recent case of UCO Bank case where the CoC, the Supreme Court has held that the CoC has the authority to return a property to the owner even during the moratorium period if it is for the benefit of the CIRP process. So here, returning of the lease property was challenged, and Supreme Court has clarified on section 14 of the IBC, which imposes moratorium on the during the CIRP. But again, it will not prevent the committee of creditors from voluntarily vacating a leased property if they decide it is no longer required for a viable CIRP process and it is going to be a burdensome on the CIRP process and cost. Hence, usually in section 14, you are not supposed to, it prevents eviction of the corporate debtor. But here, what has happened? The CoC decided that a leased property which is redundant or unnecessary, they thought of returning to the lessor. So in this case, NCLT has allowed the returning of the lease property, but however, NCLAT has rejected. Then they went to Supreme Court. Then Supreme Court has clearly clarified that although Section 14 imposes moratorium, but CoC can voluntarily surrender if it is in the benefit of the process, and CoC can legally, without violating the moratorium provisions, they have power to decide on the returning of the property, even though there is a moratorium. So here, this is the latest judgment, Supreme Court judgment, wherein it has been discussed many times that if the resolution plan is proposed, is going to create a competition and the approval of Competition Commission of India is mandatory. In that case, the RP and CoC has to take approval of the CCI. So earlier there were many times discussions whether it is prior approval or post approval from CoC. But here Supreme Court has clarified that Section 31 subclause 4 is a mandatory in nature, and prior approval of CoC, before CoC approves any resolution plan, the RP and CoC has to go before the CCI and take the approval from Competition Commission of India if it is a combination resulting in a combination in the resolution plan. So here in this is also one of the latest case laws wherein CoC, the plan was found unimplemented and rejected for lack of feasibility and viability. Here, resolution plan, although once approved by CoC, again ultimately treated as unimplementable, and it was non-viable because of funding and unequal treatment of creditors. So here there was an apprehensions on the funding of the plan amount, and also there was unequal treatment of creditors. So because of this, NCLT has raised the issues and sent back plan to the CoC. So again, CoC can either approve or reject the revised the plan on the commercial based on its commercial wisdom. And NCLT has said it will not interfere again on the commercial wisdom. So in this case, there were another issues also based on which the resolution plan was sent back. This is another case law where the resolution plan was sent back to the CoC to reconsider. There were five issues in the resolution plan, and they have asked for an addendum for adding some clauses for the implementation as well as addressing the PF dues and also providing the comfort letters for funding. So here there were only specific corrections which were made by the CoC, and the correction were requested by CoC, and RP has sent this for corrections from the SRA, and those were only specifically related to addressing some issues. Here what has happened, the specific corrections were made, the CoC was bound to deliberations only related to that corrections only. So they cannot go and discuss again on other terms. So whatever the suggestions given by NCLT, only those aspects they have to consider and evaluate, and they have to approve or they have to move for liquidation. Then the another important aspect of CoC is distribution. So again, there are a lot of case laws, judgments, and even there are many disputes among the members of Committee of Creditors on the distribution. Some majority of the CoCs always secured creditors, they always press on ensuring that the distribution is purely based on the security interest what they carry. And sometimes it is based on the voting share. So distribution, again, the commercial wisdom of CoC on the distribution cannot be challenged. So it is again CoC commercial wisdom. If they decide on the distribution, it is again it is not judiciable by the judiciary. Only CoC has to decide on the distribution. Then it should be again on the order of priority as per section 53 or security interest or voting share. So in our case, what has happened? We had 53 CoC members and 51% were secured creditors and remaining 49% were unsecured creditors. And the secured creditors were holding security on the receivables only. They were not holding security on any land and buildings or plant and machinery. It was only on the receivables part which they were holding security interest. So to achieve that 66%, now unsecured creditors, if nothing is provided to them in the distribution, they will not vote on the resolution plan. And it was a very good resolution plan amount which was proposed. So secured creditors also didn't want to lose that So what they decided, in case if distribution is provided even to the unsecured creditors, there were negotiations. There were negotiations among the secured and unsecured creditors regarding the distribution. Then they proposed to SRA that at the CoC meeting, they proposed that let 25% be paid to the secured creditors and around 14% be paid to the unsecured creditors out of the proposed plan amounts. That means on the admitted claims. So there was a consensus among the CoC on the distribution part. And sometimes secured creditors, they will litigate. If they have a good security interest, they will litigate for distribution based on the security interest. But however, even courts have clarified that once the distribution is decided, commercial wisdom CoC votes, if it is based on voting share, that is fine. Or even if it is on security interest, they are voting and the voting 66% is achieved, it is again the wisdom of the CoC. So again, distribution is CoC 4A. This is latest case law in HDFC Bank versus Pratim Bayal. So here, as per section 30 subclause 4, the CoC has the jurisdiction to decide on the distribution either based on voting share or as per the security interest. So here in this case, NCLAT has referred to various judgments and also there is an amendment to section 30 subclause 4. The CoC have been given the jurisdiction to take decision on distribution. Again, which is a commercial wisdom. This again has to be approved by the requisite voting share by CoC, which is again final and binding on all the creditors, including the dissenting FCs. Again, dissenting FCs has to get the minimum liquidation value. Here, the word is may in section 30 subclause 4. That indicates the CoC has the discretion to decide on the distribution. So we have been discussing what is the CoC and CoC's foray on the stance on various aspects under the CIRP process. So basically, many times the courts have upheld the commercial wisdom, feasibility and viability assessing by the CoC taking decision making. Very minimally, judiciary has interfered. So now we are going to see with the latest amendments, we are going to see a lot of changes in the functioning of the CoC, the code of conduct for CoC, which is in place. Then again, we have proposals for strengthening the CoC. Those key proposals are proposed by way of amendment to the regulations. Those are given in February paper, which is yet going to be amendments are going to come. So when we see the strengthening of deliberation recordings, if we see the regulation has giving a indication of ensuring that CoC has to record very detailed rationale about feasibility and especially compared to valuations. So when we are discussing, the CoC is discussing the feasibility, viability, they have to compare with the valuation and whether what is the value they got in compared to liquidation value and what are the market discovery efforts they have done and what is the credibility of resolution applicants, because market has seen lot of issues regarding the credibility of resolution applicants. Many plans are not getting implemented in time. So these are very important proposals for strengthening the approval of resolution plan, whether the CoC is really considering the viability of the plan and the credibility of resolution applicants, whether the source of funds and whether they have the capability to run the CD as a going concern or the revival. So all those factors have to be considered, and what is the kind of market discovery, again reissuing EOI if there is a possibility of getting the resolution plan from the markets. Then another one is rationalization of costs. That is, they are tightening the framework of CRP cost, as sir was discussing earlier. So just before that, 30 days of expenses, operational expenses, including those potential monthly cash flow reporting and CRP cost approvals. These are all going to be properly streamlined, and the CRP cost approvals are being tightened, and even delay claims management. So how the delay in claim submissions have to be managed, those are also proposed. And especially regarding the composition of CoC, where there are only related party operational creditors, there are no FCs in the cases. In that cases, how the related party operational creditors have to be excluded from the CoC. These are all few proposals for strengthening the CoC stance in the IBC. So going forward, again, the role of CoC is going to continue the same, but again with IBBI coming up with guidelines for them, that the deliberations being recorded and what are the efforts which the market discovery has been done for the asset, and how the CoC has evaluated. There's going to be a lot of responsibility on the CoC, and let's see how the things going to function. So any questions so far? Let's see in the chat box. There are no questions.
Ma'am, would you be sharing the presentation with us?
Yes, I will share with Anjali ma'am. Yes, ma'am.
Or maybe you can upload it. We can also download it now if you're okay with it.
Ma'am, this when the claims are received after the advertisement is issued, this he has IRP, he has no work but only to collect it and put it to the CoC. Is it that way, or he has to? What is the role of RP in that after the claims are received?
Sir, RP has to collect the claims and verify the claims, and he has to admit the claims or reject the claims, sir.
Ma'am, in the case of verification
For
of claims,
admitting or
suppose a
rejecting,
verification.
he can do it suo moto, or he has to bring it to the notice of CoC before rejecting any claim.
No, sir. It is again only RP. RP's role. There is no CoC role in this. Only if the claims come between 90 days and the 7 days before resolution plan, RP has to treat it as either admissible or non-admissible. And if it is admissible, he has to take it to the CoC saying that these are admissible. I am going to file an application for condonation of delay in filing the claims. Only there, CoC has to approve going to the NCLT. That's all. It is again the RP's role only.
Two questions here. One is, if suppose the claims were under verification the time that the plan is being approved. How do you treat that particular claim? Because obviously some claims remain under verification throughout. Even,
yeah.
When plan is due for approval and probably is approved also at times.
Ma'am, always it is better either you admit or you reject based on the data or information available with you. And you can always seek clarification from that respective creditor and just take a call. Because in one of our case in NCLT Bangalore, we have seen you cannot keep it under pending. You cannot keep it under verification. Either you admit or reject. Otherwise, it is going to be a litigation in future.
Okay. And there is obviously difference of opinion. At times what happens is the security with one particular bank is a land and building. And the security with the other public sector would be, say, only the working capital. So in such a case, would both of them be considered as secured, or only the land and building is considered as secured?
Ma'am, in working capital also it is a secured creditor only, because there the security would be based on the stock or receivables.
Right. And sometimes the stocks and receivables are completely exhausted, like there are no stocks available. Or, probably the receivables are also, equally not, there's be no movement in the receivables also. Despite that, also, would they be considered as secured?
Yes, they are considered secured. Yes.
Okay.
Because they have a security interest over the assets of the corporate
Sure,
debtor.
because there is of course a matter which was of course to my opinion also the same, like the manner in which you would have treated it. But the existing RP has not admitted those claims, and somewhere SBI is also of a similar opinion. So which is why I thought it was better that I take clarification, unless there's a case law which I could refer to.
There are case laws. Maybe I'll just drop in. You can drop in your mail ID. I'll try
Yes,
to
ma'am.
the case laws with you.
So can I drop in here itself, or should I be dropping it to you on your particular mail? Something would you?
Yeah,
How
you
would
can
you?
drop me a mail. I'll share my mail ID.
Yes, please.
Yeah.
Thanks, ma'am.
So any more questions, or anyone wants to share their view from the CoC stance or latest amendment? I think morning speaker would have taken amendments on the latest amendment.
Yes, he did.
So
Suppose this, since this timeline is there for collection of claims. Now, once claims have been received, now this RP, suppose he rejects the claim. RP rejects a claim. IRP, he rejects a claim. Now, can the person who is aggrieved by the rejection, he bring this legal action against the RP?
no, sir, he cannot take any legal action against the RP, but he can pursue a IA before the NCLT, asking for reconsideration of his claim based on the merits. But however, if he is not able to substantiate his claim, then he has no recourse against the RP.
Yes, yes. But then the committee of creditors, they can also reject a claim, is it?
No, they cannot reject the claim. The powers are only with RP to verify, collate, and decide on the claim.
That is adjudicate on the claims.
Adjudication is by liquidator, sir, but RP is only verification, collation, and deciding on the claim, admission or rejection.
But even if this amendment now proposed that adjudication is going away from liquidator.
Pardon, sorry, adjudication?
This proposed amendments, the morning class which we had, the liquidator will have no longer powers of adjudication also.
Yes.
Ma'am, suppose the CIRP cost, when there's a plan which has been approved and the financial creditor has been completely paid by the SRA, but the CIRP cost has not been cleared by the SRA, because normally these kind of plans are 30-day plans or 7-day plans. And under such circumstances, do you think there is any case law which protects the CIRP cost, the service provided by professionals?
Ma'am, who has done the distribution? This is the basic itself is gone wrong.
Section 53 talks about for CIRP to
there's no
cost paid, no?
distribution, because there's an understanding in these kind of cases, because the court order also captures
No,
that
no.
there's going to be a direct
This is
payment.
mandatory. See, you see the mandatory contents of the resolution plan, regulation 38. It says the CRP cost has to be paid in full. Then the distribution has to be done to the creditors. This is pure violation.
Yeah, but then there is a some, I suppose there was an outstanding of the SRA with the CD, and there was a receivable. So somehow they've made some adjustment entries between the books of accounts of both the SRA and the financial creditor, which is what the plan was, to the best of my knowledge, and this is what was approved by NCLT.
No, this is not a mandatory. There is no mandatory compliance in this plan. The plan,
So this is not a failure plan, right? This
yeah,
should be a failure plan, right?
an appeal has to be filed against the approval of the plan
Okay.
because they have not provided. It can be it has to be challenged
They had provided it, but the actual funding, what I understand, actual payment has not happened for the CIRP cost.
Okay,
And the
okay.
rest of the books, both the books of accounts have been adjusted to that effect between the
But
SRA and the FC.
no, but you can move an application before NCLT for payment for non-payment of CRP cost. So it will
Okay.
come heavily on both FC and SRA.
Okay.
Yeah. So any more questions or anyone wants to share their experience?
Ma'am, would you be open to taking up questions on personal guarantee as well?
Of course, yes. Yes.
There is, of course, in one of the personal guarantee matters where there is, it has reached the stage of bankruptcy. There is a withdrawal application in CIRP.
Okay.
So for various reasons, there's only one CoC member,
Hmm.
and the CoC member himself has not put a claim.
Okay.
And there are assets with the bankrupt, which are known. Under such circumstances, what do you think should the VT do?
So you mean to say what is the stage now in the bankruptcy process? The stage
It's an initial stage only because obviously there are no claims which have been received.
in the bankruptcy process.
Yes.
So
The only financial creditor himself has not put in a claim. As soon as the BT puts in a withdrawal application, the bankrupt will be relieved of all his liabilities across, not just the liability of the CoC member or the FC.
Yes, right. You're right. But again, see, if the financial creditor has not submitted the claim, maybe the bankruptcy trustee can write to the creditor and ask them to submit the claim.
Even if the financial creditors are applicants in the matter, they have still not come forward. And there's only been communications, there's been no application from them, despite explaining as to what would happen in case,
They are not submitting the claim.
Yes.
A mail can be sent to them stating that the process has been admitted and you have not submitted the claim. Hence, we are considering that you are not submitting the claim and we'll proceed as per the provisions of bankruptcy process regulations. You can write.
I mean, they do know the process stage, but beyond that, what do we proceed with?
No, see, what you can do is you can write a mail to them, sensitize them to submit the claim. In spite of that, they are not submitting the claim. It is always open for you to go back to adjudicating authority stating that the process is being admitted. There are assets and the creditor has not submitted the claim. So you can seek directions from NCLT only in this regard.
Okay, so in this case, do you think should a progress report be filed or an IA?
It should be an IA. When you seek an order, and always even progress report is also through IA only, no?
No, I don't know. I mean,
Yeah,
I don't think in the progress report we normally have an opposite party or something. So it's normally a one-sided monologue, like the way the CoC reports are submitted.
no, right, I agree. But progress reports are also filed through an IA asking for taking on record the progress report. So there will be a prayer. When you file a progress report, you will not have any prayer. So you will file through an IA asking only attaching the progress report, asking for the adjudicating authority take on record that specific quarter progress report.
Okay.
Yeah.
Right. So it's preferred that we wait for the quarter end.
Yeah, it's better you can wait till quarter and Well, sometimes the creditors will submit the claim, hopefully.
Okay. Thank you, ma'am.
So, any more questions?
Ma'am, do you have any views on the new code which is coming up?
See, the new code is going to have stricter timelines for admission, as well as they are also having the code of conduct for CoC and the valuation. So that it's going to be a lot of changes in the code, and with the timelines, hopefully the creditors will pursue in under IBC.
All right.
Yeah.
So when you have the fear that most of these cases are being taken to Sarfasi.
No, no, no. Mostly they will come back to IBC is what I'm saying. The timelines are strict now. The NCLT will not take any stances of that 14 days for admission. See, the timelines are stricter and even the
Sure.
process are being streamlined. You know now that there is a circular on the corporate data where there is an ED attachment, pursuing a separate applications, submitting a declaration that you are going to deal the assets only for the benefit of the creditors. So like that, lot of changes are brought in, considering the practical issues, challenges in the market.
Right.
See, especially in the feasibility and viability in our session, we have seen, no, the credibility of the successful resolution applicants have to be thoroughly checked, and the source of funds, especially in large size implementation of plans. Many RPs, COCs are facing issues in the implementation of plans because of the fund constraints and no proper source of funds. So these are all going to get streamlined with this new amendments and code.
But then still they do not have something which is concrete in terms of a resolution. So as soon as we realize that somebody has not been competent to implement the plan, there should be some database to capture these names.
Right. Right, you are right. Whoever are the successful resolution applicants, you are right. There is no such database as of now.
So unfortunately, the same person goes and probably comes into one process with one person, can also go to the other process for another person, and by
Right.
that time he's again successful because obviously he's got the respective network or at least the EMD to pay during at that particular phase of the plan.
So good one. We can suggest to IBBI to have such
I do
publication.
not know. I
Sorry.
have been suggesting it on the forums. I'm not sure where exactly do we put it forth to, but there has to be one particular place where this database is created for anybody to refer to it. It's simplified rather, and
Right.
also that all the directors of such a company are actually listed there. So even if one has to verify at some point in time, it gets simpler, or some reference point is available for us to go through.
Absolutely, because even this section 29A also it will be helpful for due diligence. But
Right.
most of
It's a
the
quick.
time, I don't know. We need to check the law position whether why IBBI would have. See, usually they keep publishing. Why they don't publish this? Maybe we have to check with them.
क्या चाहिए तेरे को?
I mean, I wonder why would they not publish it, or probably they have not collated it. We are only supposed to be collating the claims and the 29A, but there's no referencer that they have created for us, like a dictionary for us to quickly refer to and then make a noting of it, so that
टीवी
there's
बंद क्यों कर
some
दिया?
starting point for 29A compliance as well. There's a part responsibility with them as well.
आगे नहीं रखो.
No, actually, that's a really good suggestion. We can consider suggesting to IBBI through IPA.
I'm sure, like you would be able to represent some of these good ideas that come across in these forums.
Really helpful, yes.
Thanks, ma'am. I think I'll put you a small mail on the claim part of it if you could assist me with the case laws also.
Yeah, sure.
Thanks.
Thank you. So, Anjali ma'am, hopefully we have completed all the session and taken the questions, queries from the participants. Any further questions or someone wants to share their experience? Otherwise, we can conclude.
Okay, ma'am. Participants, if you have any questions, then you can ask. Otherwise, we have to conclude the session.
Okay, kindly share the PPT.
Yeah, I'll share.
Yes, we will share.
Okay. Thank you, madam. Thank you very much.
Thank you, sir. Thank
Thank
you.
you very much, ma'am, for giving your valuable time and for such a nice session.
Thank you.